Good morning, everyone. It is 8:30. And subject to the chair's call to order, we'll begin.
Call the meeting of the Engineering Committee to order.
All right. Thank you, sir. All right. Let's do a roll call then to make sure we got quorum. Mr. Collins.
Here.
Dr. El Sayed. Mr. Jett.
Here.
Mr. Heathcote.
I'm sitting right here.
All right. Good deal. Mr. Lim. And Mr. Carter.
Here.
All right, we do have quorum, Chair, and then if we will, we'll just work our way down the agenda then, and we won't adjourn. We'll just recess because this will be one continuing meeting once we're done. Just kind of a quick reminder. Once we finish our last topic, which would be new business, then we'll just recess and then continue our meeting at 10:30 with the full board. All right, Chair, it's yours.
All right, good. Well, first item on the agenda is to provide an update from the Southern Zone meeting that was held in Little Rock a couple months ago in April. Glenn handed out earlier a copy of the notes that were prepared for that, so I won't go through all that stuff in real detail, but you want to thank Jason Carter and Dr. Ash for helping put these together. This is a joint effort for sure. In the zone elections, of course, Jimmy Chow was elected for the zone VP unopposed. I think we were surprised on the assistant VP that Stephen Twite from Mississippi was elected over Sina Najad. That was, I think, quite a shock to us. So, but had lunch with Mr. Twite one day. He seemed like a really good guy. His heart's in the right place. I think he'll do a good job in that spot. Some of the highlights of some of the things that were discussed. There was quite a bit of discussion from the Committee on Education about promoting licensure among college professors. That's an area where I think a lot of emphasis is needed because the trend seems to be going the opposite direction, where more and more professors are not getting their license. And, of course, they're the ones who are influencing the students to become licensed. And talking with some of the professors at some of the colleges, it's getting to be a real battle within the universities right now. So I'm glad to see that NCES is looking to do that. They're going to be doing some outreach, trying to help educate people on the importance of that. And I think we need to continue to push that as well. The Law Enforcement Committee, they're... Yeah.
We leave that, James. I think that's a good point.
Just need your mic there.
Sorry. I feel like my country voice would just boom throughout the room anyway. But and I need to get clarification on this. I'm asked to speak at a number of colleges and universities about the importance of licensure and professionalism and ethics. And so, one, I need to make sure I'm okay to do that, but I've been doing it for such a long time. I'd rather get forgiveness than permission, I guess. So, but
strike that from the record.
Thank you. Thanks for protecting me. But it's interesting when I go to the universities, and these are senior class members at TSU, Vanderbilt, Tennessee Tech, UT Martin, Lipscomb, so on. And I always ask, how many of you have already taken the FE? And not very many do. And my follow-up question to that is, how many of you already have jobs? And most of the time, it's not a high percentage. It's probably maybe 15 or 20%. But a lot of the ones that do have jobs are going into industry or working for contractors, it seems like, which generally don't require PEs. And then, of course, I spend the rest of the time trying to terrify them into understanding the importance of the PE and what's going to happen to you if you don't have it one day and you lose your job and you can't get one, and all the things that we may do to embellish the value or clarify the value of the PE. I think it's important that we do that. I think, we've got folks in Memphis, we've got folks in Knoxville. I wish probably that we would do more outreach and look for opportunities to go do that while these kids are still in school. And now that we've got decoupling, as soon as they take and pass the FE, they can sit for the PE. I would advocate for everybody trying to look for opportunities to do that.
Yeah, the only time you would need like prior approval from the board is just like if it's a conference with a registration fee because it's subject to reimbursement and travel policy. That would be it. Other than that, I mean, outreach is what we all do. You know, that's a part of our educating the public. So you're free to do that, and then that would be reimbursable, you know, but what I would say is, as a courtesy, let the staff know, because if there's a work product or something you're disseminating, we just want to, one, provide support, but two, also get all those approvals if we need them. You know, that would be the only caveat with that. But other than that, you're free to do outreach as you see fit, in alignment with that. Also, at the same time, too, you know, it's not like you have a fiduciary responsibility as a board member, but at the same time, too, without any statements that would be considered the board, you just caveat those with the proper disclaimers as well. You know, this is my opinion, not the opinion or the position of the board, that sort of thing. But what you're talking about is generally outreach, and so that you wouldn't have to bring every outreach that you wouldn't need approval for every outreach that you do with out there in your general areas. That'd be fine, and we would reimburse that. That's a part of that mission.
And I would, to add to that, I think one thing that this board can do to encourage that is these grants, because so many of these grants, the schools use them to pay for the exam fees. And one thing that, yeah, and so one thing that Glenn and I just found out about, so I'm on the advisory board at Tennessee Tech for the civil department, and the department chair came to me and said, you know, is there any way, they were under the impression, so they get the grant award in January, February, right? And they've got to spend the money by the end of the fiscal year. So that only gives them 4-ish months. And so the question was, is there any way that we can spread this out over the whole, because that basically just covers one semester. Can we spread this out to where we can cover both semesters? So Glenn and I found out, you know, I didn't know, he didn't know. They can, so going forward next year, we need to probably educate the universities. They can include the exam fees for the fall semester in their grant request for next year, so they could cover it for an entire academic year. And so that's kind of, I think, education we can do when we're disseminating the information about the grants to these schools, that, hey, take advantage of that. Because that, to me, is, in my opinion, I'm not speaking on behalf of the board, my opinion, to me, that's the purpose of these grants, right? Yes. The grant should be encouraging licensure, and what better way to encourage licensure than to pay for the exam fees to remove that barrier for people?
Yeah, that's one of the elements, obviously, that they're eligible for. But again, it's one that you can see when they come in October and they make their presentations about what they've used the grant money for. A lot of it is for lab equipment or things like that. Some of it, like for the architectural schools, is for their senior travel to go look at structures and understand the architectural significance or things like that. But almost all of the engineering schools are doing something to prepare their students for the FE, either paying for the exam if they pass it, or having classes, review classes, preparation classes for the FE. And I do agree that we should be encouraging that, if not insisting on it. Good point.
And if you guys ever want to look at the contract as well, I didn't think about that because, you know, sometimes I take for granted that we see things that you don't get to see from our side of things, but you can look at that and you'll get an idea what that scope is. Yeah.
This might be a stretch, but, you know, usually there is a faculty in charge of putting that package together and submitting it. Can we request that that faculty has to have a registration?
We won't, we can't. And, yeah, I mean, that's helpful. It's you know, especially if you're asking. It's on one hand, you've got a faculty member saying, "Hey, we'll pay for the exam that I didn't take," you know. But it sort of undermines the, you know, the thrust of what you want to accomplish. It makes perfect sense. That would be in alignment you know, so that I understand where you're coming from. That would make
Could we
perfect sense.
incentivize and adjust the amount based on that?
There is some leeway. Right now, we use a proportionate sort of spread. Alton has done a really good job keeping that together for us based on size, enrollment, and what they're asking for. And then it breaks down to, you know, there's, you know, based on what they ask for, their size of enrollment, there's a formula that proportionally distributes that. But, you know, you're freed in the committee, when the grants committee gets together, to sort of adjust that. Oh, yeah.
Just an example is a blanket, you know, you get an extra $1,000 if you do this. Just something to say, hey, this is important and this is the carrot.
That could absolutely be explored. One thing I would do is, you know, Alton, I believe you're still the chair of the grant committee. At some point, but prior to, well, I think we send out that, we'll send out the letter in June June, at the end of this month. We'll send out a reconciliation notice, which in effect says, hey, you've got to the end of this month, fiscal year, to spend your funds retroactively. You know, you can do that. So, and without getting derailed, retroactively meaning actual expense during the fiscal year, during the term. But it can, if you're paying that out for prior, you know, then that's okay. Contracts confirm that. But they close that out at the end of June, and then then they also have to give us their receipts by the end of August. And usually our letter of notice goes out sometime the beginning of September. And so we would need to have if we're going to change any terms in the contract, we would need the contracts enough time first to tinker with that, and then also so we can notice that when we send out our notice in September. So if you wanted to, you know, you could have a meeting before that. You could call that and work out and tinker with that if you want, and then submit those questions to me so I can roll those up chain and see if there's any leeway in that regard or any adjusted scope or if we need to adjust fire, we can do that. But
can we, I suppose at the August meeting, obviously prior to the October meeting, we'd like to do that. At the August meeting, can we actually call for a grants committee meeting?
you could.
Because I do agree. I would. We don't have parameters. We have parameters that establish what they can use the money for, but not pro rata. You know, there's no requirement that a certain percentage of that be used for licensure exams.
Yeah, basically, if it's within scope of the contract, then we reimburse up to the amount awarded. You know, so we don't necessarily say 30% here, 40%. We're not, you know, micromanaging, you know, what our awards. We're just saying, here's the scope. You know, you can't spend it on honorarium to, you know, things of that nature. We want to make sure it's going to the students, right? You know, equipment that they're touching and using in their exams, and that there's no sort of, and so that's why the contract's written that way. You know, their equipment, their supply, their fees, their travel, and their experience. You know, we're not trying to send a bunch of professors to Milan to study the whatever. You know, we're not doing that. You know, so that the contract's written that way, and it's deliberate. But if there's something you wanted to tinker with, you know, as far as the qualifications or incentives, and you could do that. There'd be some allowance or leeway in that regard. But the grants committee would have to have that discussion. And if we run out of time, we roll over to next year, right? I mean, so it's not like it's, you know, we're not under the gun here. We want to, our team, and we have discussion all the time. You know, we want to make sure it's done right, not fast. I mean, you've heard that expression. And so I tell our folks, hey, just slow down and, you know, look at it. We want to make sure that we've checked all of our boxes and that we're really proud of our work product, and, you know, we know what we did and why we did it. So if something ever comes back on the downstream, we're not losing any sleep at night. You know what I mean? So
Right.
as long as we're doing that, we're all right.
Yeah, I wonder if we could maybe do some incentivization for some of this. Like, for instance, one of the things that I've run across is that the vast majority of the students that take the FE are civil. And a lot of the mechanical and electrical are, in fact, encouraged not to take it from their professors. So if we could somehow or another incentivize the university to get more of their electrical, mechanical, chemical, and others to take the exam, maybe we can offer them additional funding. And another idea would be to volunteer to pay the fees for the professors to get licensed.
Yeah.
And it's, I mean, I'm ashamed to say that the new civil engineering department head at the University of Memphis is not a licensed PE.
Wow.
And we just recently hired. And then I was talking with the Christian Brothers University people, and in the civil engineering department there, you're required to take and pass the FE to get your degree.
They're in UT Martin, same.
But there is no requirement for mechanical and electrical to even take the exam.
Wow.
So even within the universities, there's a lot of discrepancies there. So maybe we can do some things to try to incentivize that a little bit.
And Alton, what I'll probably do is, typically what I've done in the past, and you guys know is in our practice, before calling a meeting, I do typically send out like a blast email, blind copy everyone, so that we're not all talking to each other in violation of Sunshine Law. But I become the intermediary, and I collect all of your comments to see if one's even necessary, because I don't want to call you in, get you all dressed up for the prom, and then, we find out we don't, we didn't need to, So I'd usually like to put a work product in front of you. That way you could start a meaningful draft and conversation instead of just sort of, talking about things in the ethereal, the philosophical. We want to kind of move that towards something action. And so if I'll send out a blast to everybody, and if you're okay with that, then I'll let you know personally what those comments were, if any, and then you can make a determination if we need one or not, or if we just wait till the next term or shortly thereafter after issuance, or whatever.
Sure, and I'd gladly be receptive to anybody else's ideas, but I think for the purposes of what we're talking about, one of the items we got to go ahead and put in the blast is that we want to at least consider establishing a required pro rata, a pro rata share of the contribution or the grant be dedicated towards licensure or preparation for the exam.
If you just, because I'll need to run it up the chain, just to see what that would look like, and so that way you have something in front of you. Just because I understand on some level. I mean, obviously I understand, what you're talking about on some level, but are you? If you can put it in writing so I can tinker with it, that'd be
glad
great.
to.
That would be really great, because then I can, I can cut it up, and then you and I could have kind of iron it out, and then I could send up to legal so they know, not legal, but contracts, which they have their own element, but so that way they know exactly what they're answering, and that'd be great. Yep.
I'd be glad to do that.
I
Thank you.
appreciate it. Yes, sir.
Okay, move on. A couple of things. The law enforcement committee is having a lot of issues with these work-for-hire websites like Upwork, and we've had similar situations with that. They said that there would be a lot of additional discussion about that at the annual meeting, so something to look forward there. They're also looking at trying to set a limit on how long disciplinary action should be considered when looking at comity and that sort of thing. So that's something we've struggled with and talked about, and so maybe we'll get some guidance on that from the law enforcement committee. The structures working group is developing some common definitions for significant structures, and they're going to recommend that become part of the model law as well, looking at higher risk structures and requiring that that only a licensed structural engineer be the one to design those. So if that happens, that may be something that we will have to consider a law change for us to be able to enact that. There's a task force that created a position statement on AI, and it's attached to what you've got there, very similar to what we've talked about in the past. So it's good to see that it looks like we're on the same path as everybody else. There was also another document that's attached that is a experience record for PE applicants. And again, this is in recognition that the PE exam is becoming more and more academically focused and not really looking at experience. And so there's a really good document in there that is very similar to what our law says, which you have to look for experience, but has some meat, some some meat to the questions, I guess is the best way to say it. So some things to ask, things to consider putting in our applications for PE exams, PE applicants, for them to be able to respond to demonstrate that they do have the experience in all of the areas that are required. I guess the other one I wanted to mention.
Hey,
Yeah.
did you notice that one of the topics at the national conference was on the exams? How the questions are developed
Yes,
and processed?
yes, yeah.
So I did sign up to attend that one,
Yeah, Yeah.
which I think is important.
yeah.
And I think probably it's going to be attended by every academician in the NCAAS.
Yeah, I mean, we've been a lot of discussion of that, both at the last two Southern Zone meetings as well as at the last year's national conference. And it's something that I think everybody is really focused on right now. They're looking at alternative questions that don't require just a selection of an ABC.
Yeah.
But more
Practice-based.
practice-based.
Yeah, good.
And so that's where they're aimed with that.
I like that.
Yeah. One last thing I'll mention is that there is a motion to recommend that the member board executives have a position on the board of directors for NCES. So that'll come up as a motion at the national meeting as well. And they had a really good point that most of the people who have the most experience in NCES and have been around the organization longest are the member board executives, since everybody else's terms are limited somewhat and rotate on and off, so it would provide a lot of continuity to the board. So, any other questions you might have about any of that? I'd be glad to answer them, or Jason or Ash might want to add some stuff too.
Yeah, I took for granted that NCAAS didn't already have that. I know NCARB has done that. NCARB went as far as even to consider allowing them to serve in executive leadership, and so that was debated. But having somebody on the board they've done that for some years for that reason. That's why they came to that conclusion. But yeah.
Yeah. Just one other thing I'll mention right quick too. I forgot about this, but there was a motion coming up to end the PE nuclear exam. And I think that has some effect on us because of TVA and everything that's going on in this area. And the whole reason that it's being recommended that it be terminated is because the volume of the people taking the exam is so low that basically the exam is not valid anymore. There's no way to test the questions to make sure that the questions are valid. And
That doesn't mean that it shouldn't be.
Right. I mean, there was one of the committees that I sit on. We had an all-day meeting for 2 days, and we talked about this 75% of the time. And everybody thinks we should have an exam. We think there's a need for it out there, but it doesn't appear that the professional societies that push, that really the ones who are responsible to get people out to take the exams are making all the effort that they need to make in order to make that happen, to get people out to take the exams. It's really kind of disappointing.
Yeah, that should be one of the preeminent examples of the protection of the public health, safety, and welfare.
Yeah. I mean, the good side of that is that there are some sections of the mechanical exam that very much apply to the practice of nuclear engineering, but the part of it that is not covered anywhere really is the power side of that. So, the board still has to make a decision as to whether or not that will be terminated. It can always come back. And one of the recommendations from the engineering exam committee was that it be put on suspension and be basically redeveloped. And that can be done whether it's terminated or on suspension. Either one of those, that can be done in either case. But they really need to look at what I understand is the current exam is very, very heavy on power and very light on all the other elements. And so making that more broad in scope would be a function of getting people on that committee that have that expertise in order to be able to develop the exam to make it broader, and possibly then it could be more people taking the exam.
Yeah.
Any other questions or comments on that?
Yeah.
There was also on
Dr. Ash?
page 6 of this handout here, you will see that draft proposed NCAA's engineering technology education standards, and halfway through that under item B, they're proposing 0 college semester credit hours of gen ed courses for technology. And that's something we'll probably need to fight off in the national meeting, because that will generate a lot of friction. The regular engineering programs have a requirement for that, so why not the engineering technology programs?
Since we're on that topic, engineering technology, that we only have one engineering technology pathway 5, unaccredited, and that is set to expire, sunset at the end of this month. And so we will know that pathway will no longer exist. Yeah.
Just curiosity, did the reason that was implemented get satisfied? I don't know how to delicately ask that question.
Well, I mean, any pathways that, well, let me see if I can help out there a little bit. Like any pathway that is not, or any statute that is not, that does not form or generate through departmental bill, and every statute is moved forward by sponsors, that, of course. And so we can't be our own sponsor. We can make recommendations through departmental bill, but that was it. This one wasn't a departmental bill, wasn't a recommendation, didn't originate with us. Or sometimes associations will, present red lines to their sponsors and their respective jurisdictions, who will then move it forward. And it starts in committee, they vote on it, and then it goes to general, vote, that sort of stuff. But so that was the process, like any other. So they got 2 sponsors, and then it moved to committee and was voted on, and then we of course we enforce it. So
We do, but it sets kind of a dangerous precedent. It's happened now, and there's nothing to prohibit it, I suppose, from it happening again.
How many went through that process that you know of approximately?
Yeah, I don't know off the top of my head, but I mean, it was more than I thought, but it wasn't like, flood either. I was expecting like the subject of the inspiration of that bill and maybe one other, but it was a little more than that, but more of a trickle. It wasn't like a full on,
Less than 10?
I wish I had that number for me. Yeah, I can get that back to you. It's,
Yeah.
I would like, just out of curiosity, I would like to know.
Now, I would say I won't be able to give you hard numbers on that, because we don't do what's it called? We don't put modifiers like some other states. We don't license just mechanical, just electrical, so I can't plug it into core and say, give me all the technology paths. So it would be me just basically going back to Ashley and saying, hey, can you pull some of those applications? It would be rough. I couldn't say that was the number, and just so keep that in mind. It would just be yeah. All right, and then I was really pleased with like you said, Chairman Collins, you mentioned that you guys landed where NCAAS and NCARB did on AI with that, and they did all their work in committee with all the experts, and you guys just instinctively knew that it's a tool and there still needs to be responsible charge, and you need to know its limits and be competent in it, and that's what everyone else said. So good job.
That might be a challenge here in Tennessee, because I don't know if you look at that familiar. The one big beautiful bill has a clause in there about AI that all the regulation and the control over that will be at the federal level, and Senator Blackburn is fighting that off. It takes the control away from the states.
Yes, sir.
On the deal about the education for the technology degrees, if we're going to fight that, I think we need to come up with a proposal for what we think that general ed requirement ought to be, and we need to start talking to our counterparts in the other states so that we can get people on board with us. So, if you could maybe make a recommendation into what that number ought to be, and then maybe as a group we can put together some sort of a letter to send out to the other boards to bring that up before.
And
the
they
next
usually
meeting.
do that. You've been on the floor before. If you, typically, there's friendly amendments. You know, a lot of folks, if you're saying, I don't like it, then the first thing they do is say, well, what do you like? Is there anything you want to change? You just not like the whole thing? Or, you know, so you do want to be prepared with some,
Yep.
you know, with a response in that regard.
Yeah,
Yep.
try to build some support beforehand as well.
Yep. Good point. Thank you. All right, any other comments on that?
Okay.
Okay. Chair, we can move on to the next one if you're ready.
Okay, yep, go ahead.
All right, looks like we've got 2 fresh start reviews in front of you. We've got 1 application review, and then we've got a matter of procedure with the comedy application review. You remember we already decided on how we were going to handle those applications in comedy review. Now we just need to, you know, we need to add that language to the policy. That's it. You know, so we'll get there. That should be pretty much housekeeping since we already voted on that action already. Now we're just deciding on the language. But so the first 2 in front of you, fresh start. We've got, let me get the first one. Looks like Detman. In addition to documents provided by the potential applicant, the prospective licensee has indicated that he pleaded guilty to wire fraud in 2019. The conviction was in relation to engineering work he provided while also attempting to avoid paying university 25% of the profit for which he was obligated in his official capacity as their instructor. So anyway, that's in the fresh start. The criteria for a fresh start is fourfold. You're looking at, let me just read those off to you, just put it fresh in your mind, okay? A, the relationship between the nature of the crime and the purpose of regulating the occupation, profession, business, or trade. So we're looking at, is it related to their profession? Okay. B, the relationship between the crime and the ability, capacity, fitness required to perform the duties and discharge the responsibilities of the occupation, profession, business, or trade. Any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of crime to the occupation, profession, business, or trade, and any applicable federal laws regarding individuals' participation in the occupation, profession, business, or trade. So that's the criteria, and so we just open it for discussion. It has been, and just so you know, it has been 5.5 years since his conviction.
Yeah, he's been reinstated in his
Yes.
home state.
Correct.
Yeah.
I would recommend that we allow him to be reinstated in Tennessee if he pursues it.
Okay. Did you have any
Yeah,
comments?
I think, you know, that's besides the subject, but, you know, the university should have never asked him to do that. But he signed that contract and agreed to it. To me, if he got reinstated in his home state and where that incident took place, that's good enough for us
Yeah.
to.
Okay. All right. We'll just need a motion in that regard, and then go from there. Yeah. So we do have a motion.
So moved.
Okay. Thank
Yeah.
you. Do we have a second?
Second.
Got a motion from Mr. Heathcote. We got a second from Mr. El Sayed. All in favor, please say aye.
Aye.
Any opposed? All right. Hearing none, then we'll allow him to continue in the process. All right. All right. That brings us then to our second one, which is Hosick. And you have his letter in front of you as well. His license with us expires at the end of next month, and he's subject to renewal if permitted by the board. So he has an active license with us already, but he would be subject to renewal at that time. So he's in basically his renewal period right now. So depending on how this goes, whether or not he'll be able to move forward or not with that.
I looked him up in Ohio too, and his license appears to be a good standing there. I was curious if anything has trickled, but it looks like he's within the 60 days of just letting everybody know. So
Yep. Yeah. Well, they're required to, if they've had any, I think it's within 60 days, or maybe it's outside that.
It's
But
60 days.
Yeah, their
Yeah.
renewal says, have you been convicted of a crime or felony? So I think he's just anticipating being proactive, and we appreciate that. I don't think he's submitted the renewal yet, but it was reaching out.
My gut feeling was to push it to the next board meeting to let a little bit more time go through with his home state, but I don't know.
Yeah, but that puts him outside of his expiration, though. That would be the only thing, because he expires July 31st,
Oh, yeah.
and our meeting is August.
Yeah, that's true.
Well, he hasn't been sentenced yet either. That's scheduled for this month. And if he is sentenced, then that may resolve the issue for us anyway.
Right, right. Again, same criteria, as I articulated before, so that'd be directly related to his occupation and his ability to continue in that occupation. Yep.
Yeah, and to that, same as the previous applicant, as a father, as much as this disturbs me, it is unrelated to the practice of engineering, so.
But he did plead guilty to a felony.
Right.
And the nature of the crime itself has to weigh here.
We don't, possessing criminal tools.
Not sure what that is, but the other part of that is equally disturbing.
It's
Yeah,
typically,
yeah.
I haven't looked at it, but it's, I'm putting on all hats. So again, I haven't looked into it, so just, take it for a grain of salt, but it's typically, it's the means, the platform to commit that crime, so whatever the crime was, in this case, could have been a computer, could have been whatever, I don't know, I have no idea, but it's.
But it's
I
a
doubt-
testament to the integrity and character of the individual.
It is,
I mean, our rules say the making truthful statements and all this, but as it relates to our profession, I guess that's the caveat. Is that the part that hurts us? Because we could extrapolate that statement and not spend much time with this on this at all, but.
There's like two parts of this. There's the statute that creates the board, right? So, and this is under 62-2308, just that he's found guilty by a court of competent jurisdiction for any felony.
Yeah.
But then it specifically says any action taken, right, is going to be subject to, and it references the Fresh Start Act. So, subject to the exemptions in this section unless prohibited by federal law, a licensing authority shall not deny an application for license, certificate, registration, or refuse to renew, so on and so forth, that does not directly relate to the applicable occupation, profession, business, and trade. And that, does include felonies of crimes of moral turpitude, which I believe this falls under. But
Yeah.
I'm confused a little bit. It seems like, so he's pled guilty.
Yes.
Yeah. So there's no.
So
Basically, if you choose to deny him a license, so Glenn read off those factors earlier, what happens when we deny somebody a license based on a criminal conviction is we have to send them a letter basically saying, here's why we're denying you, here's the justification for denying you, and here's the earliest date for which we would consider reviewing reapplication. So we would have to go through those 4 factors and discuss like why we think these factors, why we think the situation meets the requirements of these factors. So you would have to make the argument that there is a relationship between the nature of the crime and the purposes of regulating the occupation, profession, business, or trade.
well, I certainly think this rises to the level of moral inturpitude.
Yep. I would agree.
I make a
I mean, you would
recommendation we
have to
deny.
articulate for the record why that would relate to somebody practicing engineering.
Again, it's a testament to the integrity and character of the individual.
Okay.
Glenn, could you read the 4 things off again, please?
Well, wait, I'm going to go through them one at a time because we actually have to sort of state if we're going to, and to be clear, I'm not saying we're going to do that, but since it seems like we're going to have that conversation, I'm going to try to write some of these down. And then at the end, I'll read back to you. And then you can decide how you want to go if you think that this is appropriate. Okay, so the B is the relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the occupation, profession, business, or trade. So what about this crime do you think specifically affects this person's ability to work in this profession?
just going to think out loud here for a second.
Yeah, please
but-
do, yes. This is just a discussion. Right now, I'm just taking notes so that in the end, we can decide how you would like to vote.
In his own words, he goes back to a previous time period when he was licensed and providing services and said the incidents occurred during a period of extreme personal and psychological distress. I experienced a sudden unexplained medical condition, creating health issues, emotional strain. But by his own words, he was not mentally capable of performing a highly cognitive functioning job of being an engineer in regards to health and public safety. So I sought therapy, continuing to work with a licensed mental health professional. I don't know, I'm just thinking out loud of saying it's already, you're kind of already saying you shouldn't have been practicing this at all.
We don't know any details about this incident. It's just his statement here, but where it happens is it in the,
Do we have the police record?
where exactly, no details.
Do we have the report?
I know that.
So I have in the previous time period where he was practicing, the instance occurred because, according to the applicant, because of medical conditions, extreme distress. And you feel like he himself is stating he was not mentally capable of conducting, like, oh, I'm sorry, I should have made sure you. What I have written down is, in the previous time period while he was practicing, the instance occurred because of, according to the applicant, the instance occurred because of a medical condition, extreme distress. And you think that the individual himself is saying he was not mentally capable of conducting, like, cognizant,
Highly cognitive
okay.
cognitive functioning engineering judgments, if you can't make the moral judgments
Yeah,
that you pled guilty to, that would be what I would, it's kind of pointing out the obvious. If I can't make decisions on possessing criminal tools and attempted unlawful sexual conduct with a minor, how can I design structures for?
Well, the one other element, Laura, too, is he admits that he sought
There.
a forensic psychologist, the opinion of a forensic psychologist, to say there's a low risk of recidivism, but that doesn't mean there's no risk.
he said there's a low risk of recidivism?
Yes.
Yeah.
Second paragraph.
Yeah.
And the psychologists will never say will never say there is no risk. They will always, have the
Yeah,
company know the disclaimer, so.
Which, understandably, if somebody's committed a crime, a criminal act, and has pled guilty to it, there's always going to be a chance of
Yeah.
recidivism. They've done it once.
Okay, so C, any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of crime to the occupation, profession, business, or trade. So what rehabilitative efforts do you think are relevant here?
He's indicated in the last paragraph that he's in therapy, and he's committed to doing the work to allow him to better understand the underlying psychological issues in order to take real steps towards recovery, which clearly indicates he's not fully recovered.
And just in case it comes up while she's bringing that, just to give you a quick update, this came in as in our call center as a ticket, and the letter is all you have in front of you. What we do, and we always do this, is when somebody gives us indications like this, we immediately ask for the court documents so we can get them a better summary. But that's why you don't have it in front of you, because we haven't received that yet. Okay, so yeah.
So are we required to do anything at this stage?
Well, he's asked for reinstatement.
Yeah, he's going to be going through renewal, and so we could.
He's hoping to get probation, but he's asking for reinstatement of his license when it comes due.
When it comes, so.
But it's coming like
In a
in
month.
July. So he needs a decision.
And he's, if you notice the dates, he's 59 days.
Yeah.
If you look at the letters, and we could use that to deny it if he were 61 days, right? His communication, I'm writing to do for that on March 21st.
It would be
I
a
plead
complaint,
guilty.
like, you know, the best we
April.
could do would like open a complaint if somebody was to, you know, not follow the rules, but we wouldn't be able just to deny the application based on that solely, yeah.
Yeah, I'm just saying it's 59 days,
Yes, he's
and
watching.
it's like 61 days, and that would be something else we would add to it.
Right.
That would be.
And then lastly, is any applicable federal laws regarding an individual's participation in the occupation, professions, business, or trade? I am not aware of any federal laws that would not allow this person to be an engineer.
He just couldn't work on schools, hospitals, different functions where the general
That's-
public,
That's a good point.
Parks.
parks. In fact, there's quite a few in the field of engineering.
That's a good point. Okay. So, because we don't. This is a little unusual because we don't have all the documents.
Yeah.
It seems like the board is considering voting for denial. If we were to do that, we would need to talk about, like, when would, because, I mean, we've discussed he is in therapy, he's committed to doing this work. He did see a forensic psychologist, so we would have to discuss, like, when would the board consider reviewing his application again? Like, what would be an appropriate date for that? But also, should we, like, just defer?
Yeah.
So he might go into an expired status, but
Yeah.
The board meeting is like a week after that.
yeah, the board meeting's a week after that, so we could always
So that would
choose
Well,
to
by-
waive penalties if it was determined he was going to be reinstated.
And by
based-
the time of the board meeting,
He'll have,
the sentencing would have occurred, and probably the state of Ohio may have already taken action too.
Yeah.
and then we'll have the documents, so I think at this time, we're voting for denial or not. If somebody wants to make a motion with the understanding that it's really more of like a deferment denial. We'll discuss again at the next board meeting, so long as we have the appropriate documents.
Then I would like to make a motion to deny the applicant's request, but to revisit it once we have additional information, hopefully by the August board meeting.
Okay.
I'll
Second.
second that.
All right, we got a motion, Got a motion from Mr. Heathcote, and we got a second from Mr. Carter for deferment until the next meeting. So, in effect, basically a denial at this point until we get deferred, until we can review it again at the next meeting. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none. That one is approved, and we'll let him know, and then we should have those documents for you at the next meeting.
Thank you, Laura and Glenn. We know that was a challenge. So we appreciate your guidance on that.
Yes, thank you, Laura. Appreciate it. Okay. I think we're ready for our application review then. Let me get all my documents out of the way. We're looking at, we've got a individual here, original violation in Texas about 9 years ago. That's really what we're looking at more than anything else, because then all the other violations flow out of Texas. It's everyone else sort of following suit. So Texas violations are we're looking at, and you do have that in front of you as well. And we're reviewing it under 62-2308. The board may refuse to issue or renew and revoke or suspend the certificate of registration of any architect, engineer, landscape architect, interior designer, registered with the chapter who is found guilty of, and then it gives you a list of items there: any fraud or deceit in obtaining a certificate of registration, gross negligence, incompetency or misconduct in the practice of said professions, or failure to keep and utilize the registered seal. We don't have that. By a court of competent jurisdiction, of breach of contract of professional services. We don't have that either. A violation of the rules adopted by the board. But so it looks primarily looking at the purview there, it appears, is Part B of gross negligence, incompetency, or misconduct in the practice of architecture, engineering, landscape. So if we're looking at 62-2, 308, A, B, and there could be some other potential exposure elsewhere, but that's primarily the scope. So with that in mind, so this was 9 years ago with other violations stemmed from the text issue. The structural issue was the impetus for this discussion. Typically, based on prior decision, we would, if they were reinstated elsewhere, and then that's where it gets kind of squishy too, because they weren't completely reinstated in some of these jurisdictions. We've got sort of restrictions. So that's where it wasn't clean. We had to come and have that chat with you guys, because typically, as we will see in our comedy, the decision there is if it's older than 5 years, they've been reinstated. But that's a clean reinstatement. And that was the decision. Here we don't have that. We've got restrictions in some of these areas based on what was perceived to be him working outside of his competency level. So I'll pitch that to you to have that discussion.
So one of the conditions that was imposed upon him was that he would cease and desist from designing buildings over 1 story tall until he had gotten additional education, passed the structural exam and all that. Did we get anything from anybody to know whether or not he's done that? Okay.
No. As far as I know, those restrictions are still in place. We did reach out, like we always do, to those jurisdictions for as much information as we possibly can get, asking those questions. And the reply was that he's still under that restriction. So that would indicate that he hasn't passed that exam and hasn't cleared that. So he's still under that restriction.
And we do not have in Tennessee the ability to do what Texas did to him.
Yeah, Texas, they don't. What they did was put special conditions on him by agreed order. But here's the problem. This is the rub for Tennessee. One, we don't have restricted licenses. They get a license, and now, and this would be, I don't even know necessarily we want to open up that can of worms, but, what Texas did was say, based on agreed order, I don't know how they manage that, because unless they have a really robust public search, the whole, if you have a restriction on someone's license, the public's not going to know that unless they can readily pull, because what they're going to do is they're going to do a public search and verify that license, and they see a license, they don't know that he's got a 1-story restriction, So unless we can't, as a board, I wouldn't recommend even having that discussion until we have that functionality, until they can pull up their license and see what restrictions exist, in a way that would communicate to the layperson, then it's kind of the it's either going to be a revocation or not, or accepting the license or not based on the merits, but we wouldn't be able to. There's no way for us to separate it out based on the current, this range we have now.
In our case here, either we're going to grant him a licensure or not.
Yes, sir, that'd be right, yeah. I mean, you could, after the fact, if he had a license, you could discipline him by complaint, but, that's not, yeah.
Do we know when they prorated his suspension? It was a 2-year suspension. Do we know when that expires?
I believe it's when he meets the terms of that. It's 2 years, but that keeps getting pushed out. When I used to be a probation parole officer, it was always, you'd have a term, but if you violated that term, you still had to meet all the special conditions within that term.
Yeah.
So that's a lot of time, and they're saying no longer. Like if somebody had a 2-year suspension on the criminal side, or excuse me, probation on the criminal side, it was that 2 years, and you had to meet all these terms. If you didn't meet those terms, it kept getting pushed out. But there's a light at the end of the tunnel for the offender if they meet all those conditions within that period of time. But they haven't met those conditions. I've had folks that were supposed to make restitution, and they had their probation revoked and extended, for years, because they thought they were just going to write it out and leave the bill with their victim. That's not going to happen.
I just looked it up on Texas, and the only thing it says is active and current. So it looks like, this is my point to you, is that I don't know that their restriction and instruction to him is any different than our instruction to the engineering community to practice in your area of competency.
And if your purview is, if the reason we all got dressed up and came here was public health, safety, and welfare, and they don't know what his agreed or what his agreed order says, that's a problem.
Yeah.
That's interesting, because I looked them up 2 days ago, I couldn't find it.
I did, I looked up his number. Did you look up his number or name? So 100066.
So I haven't seen. I have learned from admin that they're going to beef up the disciplinary action report, the DAR, to make that a little bit more robust. Probably searchable online, and we'll have it right there, front and center with public search or verify eventually. But until we're there, I mean, that really, to your point, Dr. Ash, this is a discussion about whether or not we're going to allow him to pursue licensure just based on the merits we have right now. Yep.
This says this was updated 6/4.
Yeah, because I looked at it
Yeah.
6/3, and he was not there. So, I mean, it's kind of,
Conspiracy.
so he might have met the requirement, and,
We not know.
yeah, we don't know.
Yeah, and to be fair, our conversation with Texas was just a couple days ago. It's possible that our conversation with them prompted some action on his part, and he decided to wrap that up. I'm not sure,
Those are not short order items to wrap up, though.
Yeah, that's right. He had to be already in process, at that point. Yeah, that's right.
Can we request additional information about what he has done to get reinstated? Or
You can, yeah. You can defer that one as well for additional information up until the next meeting. But Texas may very well come back and say, no, what we gave you is it. It just took they just took that much time for it to update.
Are you saying request it from him?
Do you want a statement
Or
from him?
Texas.
Is that what you're saying, or Texas?
Him or Texas?
Yeah.
Either.
Yeah, we reached out to Texas just a few days ago, and so the last they left it, shy of 1 week, a few days ago, was that he was still on probation. He still had those terms, so he still was on restrictions.
when
Yeah.
I was looking, it says that, well, when they only list active licensed engineers. So if he's listed now, something might have happened.
I mean, what you could do is say, you could also make a sort of a conditional decision in terms of if nothing has changed, or if he hasn't been fully restated, then we just deny it.
Yeah.
You know what I mean? You could do something in that regard.
Some of the conditions of his, settlement were that he had to pass these ethics courses and that kind of stuff. I know one of the other applicants we were looking at earlier had supplied evidence, a completion certificate for the very same courses. If we could ask the applicant to provide information to show that he has completed.
Well, one thing you could do is
Going back to your original point, if we go down that road, then we go down the restrictive road. Isn't it much better for us to say, only if you're full status in Texas can we renew your
yes.
license?
You could say that you could be he can represent his application. It would be a denial,
Yeah.
right, based on what we know now, and he can represent or reapply once those restrictions have been removed. You could do
Yeah.
that, and then
Okay.
that way you're not looking at it again or dealing with that. Yep.
Then we're not managing those.
That's
to provide
right.
Proof.
And I think admin would probably love you too. We don't like holding on to applications for indefinite periods of time, mitigating every finer point. You know what I mean?
So,
If he has not met the requirement that Texas put on him, it doesn't make sense for us to give him a license.
no.
No.
So could we put a motion in the form of to deny this licensure until those restrictions in Texas are
Yeah,
lifted?
at which point he could reapply.
Yeah.
And it would be a reapplication. We're not going to go and grab this application again. They're saying denial subject to, the fact that we don't, that he's still under restriction under Texas. But once he meets all of his obligations, that's been lifted, then he can reapply. Is that your motion then?
Yes.
All
So
right.
moved. So moved.
Do we have, we got a motion from Mr. Jett in that regard and a second from Dr. El Sayed. Do we have all in favor? Please say aye.
Aye.
Any opposed? All right, hearing none, that one's passed, and we'll let him know. All right, so that leaves us to the comedy application review policy. That will be in your general documents because under number 4, that won't be under engineer committee. It starts with you guys because obviously that decision was voted on already, And you'll see I've highlighted there under the comedy application review. So number 4, comedy application review, you'll go down to your full board documents, and you should see that policy in front of you. The highlighted portion is what I've added, and that's what we need to discuss there. If you remember, that was the decision we captured just last meeting. And so what we're doing now, though, is we've made that decision, but because we have a policy, we need to update the policy. So I took that decision and incorporated it into the policy. So any discussion?
I move that we update the policy accordingly.
Second.
We got a motion by Mr. Heathcote, and we have a second by Dr. El Sayed.
Discussion item.
Yep, we'll do it. For discussion.
Prior discipline in another jurisdiction at least 5 years and the license was reinstated, remains active status in the same jurisdiction. Should we put in there based on what we've been reviewing without any restrictions? Would that be a right thing to put in there?
Status.
Active status without restrictions.
Yeah, we could do that, yeah. I mean,
Just
it's
like Texas looks up and it says active.
Yeah. I mean, it's interesting that we just had this application right before that, right? I mean, it's sort of implied, but it's always better stated, right? I hate when things are implied or be based on the full weight of something. We've dealt with some of those in other discussions, and it's just nice to have it stated. So what your recommendation then is, and remains in active status without restriction in the same jurisdiction as the state of discipline.
I accept that amendment
All right.
to my recommendation.
All right, sounds good. We've got a friendly amendment by the gentleman from Brentwood.
I'm glad you did that. We're fixing to fight.
And Dr. Ash, or El Sayed, are you good with that
Yes.
as a second? Okay. So we got a motion from Mr. Heathcote and then one from Dr. Ash as second. All in favor, please say aye. Oh, okay.
Ooh,
Yeah. So we've got this for engineers. Should we not also have similar language for the architects? I know that
Yeah.
people need somebody to talk about that, but
Yeah, just
consistency.
yeah, I noticed that as well. But yeah, that would be something the architects, they probably have to meet in committee and have that discussion. They could do that in the full board if they're just ready to say, yeah, well, us too, then we
I would
could
assume
do
that would still apply to the landscape architects.
And what we'll probably do, and we will do, now that we've had this discussion, we'll pitch that to the board, get their vote on it, and then as a secondary follow-up issue, the full board can, with the architects present, can decide if they want that language as well. But yeah, but for committee, since our purview is engineer, it'll be as written or with that amendment.
Call for a vote.
All right, all in favor, please say aye.
Aye.
Any opposed? And then, all right, that one's good. We'll add that caveat. And then new business. Chair, did you have any new business?
I don't have any business. Does anybody else have any new business?
All right, well, we won't call for adjournment, obviously, since it's a continuous meeting. So we'll, if it pleases the chair, we'll recess until 10:30. All right, very well, thank you. All right, looks like it's about that time. If we want to find our seats, and we'll get started here at 10:30 sharp.
Showing Ariel, Laura.
Not yet, all of them.
I was showing Ariel, Laura. They're at the corner.
Yes.
It's like, it's a lot. It's a lot. It's like, this is why you have to eventually leave academia. When you don't.
Yeah, I know. That is so true. That is so true. Everything is shorthand now. When I was back then, it was like, All right. According to my clock, it says 10:30. Is that what you've got there, Chair?
Yes, sir.
All right, then we'll get started then, if you will, if that pleases the Chair. You want to call us to order?
We will call to order the June, if you can believe it, meeting of the Board of Architectural Engineering Examiners.
All right, thank you, sir. All right, so roll call then. Jason Carter,
Here.
Melanie Doss,
Here.
Blair Parker,
Here.
Rick Thompson, Brian Tibbs, Frank Wagster,
Here.
Dr. Ash, Jeff Nally, Alton Heathcote,
Howdy.
Eddie Jett,
Here.
James Collins,
Here?
and then last but certainly not least, Mr. Philip Lim. He is your new board member. Yeah. Welcome aboard, sir.
Hey, like a return of the ghost.
Well, we're glad you're back. And he comes with us with a lot of experience. 17, 18 years, sir? How long was that?
I started as an associate member in 2000. Then I retired. The last meeting I was here October 2018.
Okay, so he brings a little some of that legacy experience to the board. So he already kind of knows what to do, and he'll be getting some applications. Ashley was over here like chomping at the bit to get after you. So yeah, you'll probably get some of those applications here pretty soon. But but thank you. We're glad to have you, and looking forward to your contribution. All right. Looks like just a couple things. First of all, the notice of public comment period. I just always try to highlight that will come at the end of the meeting, right before we adjourn. So that'll be the last thing there. And if anyone's listening online, they'll just need to sign in to the chat there, and then Miss Griffey will, when we get to that point, we'll acknowledge you, and she'll give me that list, and will those that are present, should they also want to make a comment, they can do so by signing the sheet behind me at the podium, and then we'll make sure that we acknowledge them and give them 3 to 5 minutes for any comments they have on items related to the agenda. So we'll do that then. The meeting notice of the June 5th, 2025 meeting of the Board of Architectural and Engineering Examiners has been noticed on the website since December 18th, 2024. This month's agenda was posted on May 29th, 2025. I didn't have any other announcements, and we've recognized Mr. Lim, so unless there's any other announcements from the board, I think we can move to the agenda. Do you have any announcements that you'd like to share with the board, Chair? Okay. Hearing none, then we'll move on to adopt the agenda.
So moved.
All right, got a motion from Mr. Parker. Do we have a second?
Second.
A second from Mr. Wagster. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, then the agenda is adopted. All right, approval of the meeting minutes. Should have those in front of you. Do you have any edits from our April meeting?
So move.
All right, we got a motion from Ms. Doss to approve the April minutes. Do we have a second?
Second.
Missed that one. Was that Mr. Parker? Oh, Waxter. Okay. Got a motion from Ms. Doss. We got a second from Mr. Waxter. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, then we've approved those minutes. We'll get those posted then. All right, professional society reports. Is Miss Anderson here? All right, so we don't, what about online? Is Miss Anderson online? No? Okay, you got it. Okay, perfect. All right. She sent Nathan Ridley, of all people, Nathan Ridley.
Good morning.
Good morning. Go.
Bingo. Good morning. I'm not Nathan Ridley. I'm Casey Anderson here submitting her report. She has to be out of town today for a funeral. An uncle of hers has passed, and y'all know funerals are for the living, so she's doing where she should be right now. But she does have a few words that she wanted to share with the group. They have the ACEC has a leadership program, and they had their graduation ceremony just last week here at the Capitol for the class of 2025. And those are just like all graduations. It's quite touching. I didn't get to go, but she said it's a powerful event. They also have ACEC also has a workforce development committee, and names that y'all will recognize that the leaders. Rodney Chester of the Gresham Smith firm here in town is the chair of that. And then one of the co-chairs is Susan Oysterberg with the Smith Seckman Reed firm. And that committee is focused on 3 areas: new and future workforce, retaining and developing current workforce, and then, of course, legislative and regulatory and policy work. Their upcoming events are June 16, 18. They always have a partnership meeting with their friends from TDOT, and that's going to be at the Chattanooga Convention Center on June 16 to 18. And then July 13 to 15. 15. They're going up to Washington for their annual fly-in, their congressional fly-in. They have their state conference in September, the 14th to the 16th. And then the first week of November, they have an annual vertical conference and our Engineering Excellence Awards. So that's a Casey Anderson report for ACEC. Thank y'all for indulging me and letting me speak on her behalf.
And Mr. Ridley, if the rest of the sides will indulge me, while you're up there, we'll just go ahead and let you give your report. Is that okay?
Okay. Now I am Nathan Ridley, and I'm here on behalf of the Tennessee chapter of the American Society of Landscape Architects. We just had our annual conference in Knoxville in April, and that's always a good event. Like all professional societies, we're still trying to recover from the COVID. So getting people used to seeing each other face to face instead of squares on a screen is a good thing, and we're getting better at it. And to that end, we just had a strategic planning retreat with our leadership, our executive committee this past weekend, and we're waiting to do those. If y'all have ever been in one of those, usually you have a facilitator that's not a member of the group, and you have to pay them a little bit. And it's a little bit of looking at your watch and telling you what time it is, but they can sort of point you in the right direction. She was very helpful, and her report will be available just in a week or two, and I think that'll be helpful for our chapter. I usually talk about the legislature a little bit. I can't help myself. The session ended towards the end of April, and for the practitioners in the room, you probably want to take a look at Chapter 437, dealing with wetlands. Site developers have always lost a site because of what I might call a tractor rut, man-made or artificial wetlands, and the bill addresses that. That will make your development plans a little easier. That's Chapter 437. And you got to give a shout out to State Representative Kevin Bond from Collierville in Shelby County. He was the House sponsor, and had it not been for his persistence, he's been working on this bill for 3 years, it wouldn't have made it across the finish line. And then the very last item is it's a layer removed from this board, but the Division of Regulatory Boards has a rulemaking hearing scheduled for late July, maybe July the 24th, about advisory private letter rulings. And the legislature authorized boards to do those by statute in 2024. And I have it, I'm about to tell you more, and I know, but be careful, not careful, just be sensitive. To me, private doesn't mean secret. So the Department of Revenue has a similar program, and they redact some stuff and issue a summary report at the end of the year. So just ponder that. It's not in the rule, the proposed rule right now, but is that in our chapter and other professional associations might have a comment on that. That's all I have for today. Thank you all for your time. I'm happy to respond to any questions or comments. Okay, thank y'all.
Thank you, Nathan. Appreciate you. All right. Okay, that sounds good. All right, so then ACEC or Susan Herron or company? Okay, perfect.
Hi, good morning. Will McCloy, not Suzanne Herron, but with the American Society of Civil Engineers. So brief update for what we've got going on. Our membership totals still for the state, we're looking at just over 2,700 members. 524 are student members, so great numbers. Most recently, we had our golf tournament, which happened end of May. I don't have the exact numbers, but it's usually a well-attended event, good sport, good sponsorship participation. So looking forward to that. We're also in talks right now, based on the last board meeting. We are going to be having, we're calling it the Engineers Symposium, which will be our new conference coming up. And I believe the date for that is set for February 13th, 2026. It's going to be a little different. Usually we had our engineers conference in the falls. This time it's going to be in the spring of 2026. Similar to, I guess, years past, it used to be held in Smyrna, and I believe it's going to be in the same capacity there. So similar, instead of a 2-day event, it might be 1 day, but we're still in the works of talking about that, but really interested and excited to be engaged with that from the engineering side of things. That's the update I have from ASCE, and happy to take any questions or comments as well.
And then if you would, just for a matter of record, go ahead and sign in, and we'll make sure that we get you included. Yep, you're on it. And any questions from the board? All right,
Thank you much.
thank you. You guys were kind to Nathan, too. I thought you were going to pepper him with engineer questions, since he was covering for Casey, but, all right, Ms. Cates?
Good morning, I'm Ashley. Is this working? I'm Ashley Cates. I'm the Executive Vice President of AIA Tennessee. So I'm going to go backwards a little bit on my notes, but we have a conference coming up August 6th through the 8th, which I know it kind of lands on the same time frame as a board meeting, but if you're in town, we can send you information. We're going to have it in Nashville at the new Embassy Suites downtown, so it's going to be the first time that we're downtown in over 11 years just because of the price range and everything. So everybody's excited about that. We have a lot of tours going on, a lot of CE, of course. And we're getting ready for that. Registration actually is going to roll out this afternoon as soon as I can get to the office to send out an email. So also, we are working with our Northeast Tennessee members for the disaster recovery efforts in Northeast Tennessee. They're starting to try to help a lot of the rebuilding, and so I'll keep you updated on it, but there's a lot of education about codes, what can be done, what can't be done, and then looking at the changing landscape of that area up there. In full disclosure, I am not an architect, so I'm just the executive director for the architects, but the conversation is, with the flooding and how things have, how the floods dispersed the soil and other things, that the landscape has changed. And so when they're rebuilding, they want to make sure that you're rebuilding back safer and stronger. So that's the conversation that's happening up in Northeast Tennessee, and feel free to reach out to me if you have any questions or want to get involved through that group in Northeast Tennessee. Session ended, and we had a really good session this year. There were a couple of bills that we were monitoring and tracking, and AIA Tennessee sponsored a bill. It was Senate Bill 899, sponsored by Becky Massey and Representative David Hawk. And a couple of years ago, due to the tragedy of the Covenant School shooting, there were some standards put into place that where if individuals aren't educated on how the design community designs their buildings, they will put something in statute. We've had these conversations before of where they're putting codes in statute and not even realizing how hard that makes it for the design community. And so there was some cleanup language that we needed to work on, and we worked with the state on getting that language clarified, so then when our architects are designing buildings for K through 12 education, they know exactly what they need to put in for glass standards for public schools. And then also developed, gave the ability for the school safety team to discuss those guidelines, provide recommendations, and then the state fire marshal's office actually makes the rules. So then now our architects and engineers, you can reference, you can go to the state fire marshal's office, and there's some actual rules that can be defined. That's still in process, but we're working through that, and we really appreciate the state's help and the collaboration on getting that cleared up for our members. The additional pieces of legislation, we talked about that at our Day on the Hill. We also talked to our legislators about qualification-based selection. And so I know we have a QBS manual here, and it's been a topic of discussion over the years. But we want to make sure we have a lot of new elected officials that do not know the process. I mean, they don't need to, right? Because they're not an architect or an engineer or in public procurement in general. And so educating them on the process of QBS and why it is so important is of top of mind. There were a couple of bills. There was one alternative delivery method bill that was introduced that we were able to talk with the sponsor, and we'll go back and talk to him about it. But it came from believe one of the interested parties was the Public Procurement Association on taking a look at alternative delivery methods. So I just wanted to let you all know about that one. We also advocated for economic development and housing solutions. And then one of the other things we wanted to discuss was the essential role of architects. And so the top 3 items when we were talking in the offices would be protecting the public health, safety, and welfare, driving economic growth, and their expertise, collaboration, and development. And so we were trying to make sure that our lawmakers knew specifically what architects did other than design pretty houses, that there's a lot that goes into that rendering that everybody sees. There's a lot more to it than just the rendering. Other than that, we had a really good day on the Hill. I just need to thank, there's a few of our members. We had a really great, we did 3D models of the state capitol, and we passed that out with our talking points to the legislators, and we also had a tabletop for the public where we also passed out little 3D models of the state capitol. And that was such a hit, and it was the first time we had ever done anything like that, to where it was a tabletop, and our members were behind it and talking and engaging with the public that is down on the Hill. But it was an awesome way to interact with individuals that may not just want to stop by and to talk about the profession. And so we've even gotten recommendations of, we should do the War Memorial Building, or we should do Library and Archives, or we should do, the University of Tennessee's stadium. That was one on our thing. So we have a list of things that we're excited about working on the next few years to engage the public in an exciting way that maybe is another focus, not an outwardly focus versus an internal focus. So that's what I have for this quarter report. Hopefully I'll be around. If not, I'll send a report to somebody in August, since we have the conference, and I'll be busy. And we're going to be providing our newly licensed architects from 2024 complimentary registration to the conference. So that's a great way to show them everything that the AIA Tennessee and their professional association can provide, as far as especially education opportunities. So that's all I have. Question? Thank you.
Thank you so much. Let's see, Hannah Finch or Claudia Lofton? Hold on just a second. Go ahead. And then Hannah, we'll get you next, since I know you're on screen. So go ahead, Miss.
Hannah's actually.
Oh, yeah.
Yeah, I'm going to go first because I've got a jet.
Perfect. Go ahead.
So, of course, yeah, this is Hannah Finch, president of the American Society of Interior Designers. So I'm going to go through mine and then hand it off to Tiffany for IADA. So quickly going through, we do have the request for nominations live for the 2025 to 26 new board of directors for the state of Tennessee. And that board term begins on October 1st. And we are having our strategic planning meeting in August, where we'll have our current and new board. So we'll be planning for the upcoming year, setting our budgets, and we're doing that in conjunction with the National ASAD Conference, Gather, that's taking place in Atlanta, August 17th to the 20th. So we're going to update our budget, taking into account our national membership allocation changes that happened last year, and then, of course, our local annual sponsorships that we're continuing to update. And then as far as events and things going on, we have our industry partner appreciation event. That's an annual set for June 26th at Walk Your Plans. It's a game night themed projection experience. If you've never been to Walk Your Plans, that's where you can live upload a set of documents and kind of walk through them in real scale, which is pretty cool. So a tool that we can use, but also a fun experience doing like a virtual game of Clue and whatnot. So should be very fun. Of course, we celebrate our annual vendor partners while providing just a great networking experience for designers all in one space. And then we do plan to partner with NKBA, the National Kitchen and Bath Association, on a second annual student event that's serving kind of as a prequel to J&J Interior's Inspire Nashville event. So that was formerly post-NeoCon here. And details will be live in the coming weeks via social media as we continue to plan that. But we realize we have a lot of students that are home for the summer and they want to still be involved in network, which is awesome. So we'll either be doing another panel discussion, a showroom tour, something like that, and then heading over to the fairgrounds for that post-NeoCon. We are officially off for the summer is for our monthly unit meetings. So our next CEU / monthly just ASD membership meeting is for August 12th at Myers Flooring. And then our next larger event is our State Conference Design Awards. And the submissions are live and open through July 21st. Programming for that event is complete and registration live. So we'll have our awards gala on Thursday, September 18th at Riverside Revival, and then a portfolio review with HSW CEU on Friday at NTSU's new concrete and construction facility. So the theme this year is Legacy in Motion. We're celebrating ASID's 50th Golden Year achievement, kind of in line with our national conference, and should be a fantastic event. So from there, I will hand it over to Tiffany for IDA.
Thank you, Hannah. My name is Tiffany Clegg. I am the VP of Advocacy for the IIDA chapter. I first would like to introduce 2 interior design students that I have with me today who are interns at my firm, Hastings Architecture, for the summer. Maeve Taylor is a junior at Savannah College of Art and Design, hailing from Colorado, and Maggie Hooper is a junior at Tulane University and a Nashville native. So just wanted to point them out and excited to have them involved. So our updates for our chapter, we will be awarded the 2025 IIDA Chapter Award at the National Chapter Leadership Council meeting on 6/6. The University of Tennessee, Knoxville will be receiving the 2025 IIDA Campus of the Year Award at that same meeting. Our new board has been approved by our membership and will transition on July 1st, 2025. Congratulations to our new board members. On May 8th, the East Tennessee City Center hosted an inspiring panel called Mothers of Design that celebrated the experiences of mothers in the interior design industry. On May 15th, Nashville City Center hosted a trivia night focused on interior design-focused codes and advocacy questions. On May 21st, we hosted a statewide virtual CEU exploring the complexities of trauma-informed design. And on May 22nd, we hosted the reveal party for our biannual Threads event, which will be held at Geodis Park on Thursday, September 25th. Our future events will include on June 3rd, the East Tennessee City Center will be hosted a recycled material theme hands-on crafting event. June 6th through 7th, our Memphis City Center will be hosting our annual Zero Landfill event. And then June 16th, the Nashville City Center is hosting a Zero Landfill Sort Day and Canned Food Drive at Turnip Green. And that is the end of my report. Thank you.
Thank you very much for the report, and also congratulations on the national awards. Yeah. Those are very honorable.
Thank you so much. Yeah, we're very proud of our state and all of our interior designers for accomplishing a lot this year. So
great, thank you.
Hope to continue to do so.
Absolutely, and thanks, Hannah. Appreciate it too.
Thank you, ladies. Thank you, Tiffany. All right. Looks like, is there any other questions or comments as it pertains to our professional society reports? All right. Looks like we're ready for the next rung on the ladder here. Director's report. So the budget report will just be informational purposes only. No action there per usual. And then of course we'll have a comedy application review policy. So with some additional language we'll need to discuss then. All right. So for the budget, all right. Let's see. At our last review, we went through financial reporting through February. We currently have 2 more months of record. That's March and April. So we'll focus our attention there on that one. You will, you probably already did notice an increase in administrative cost spec charges for technology. That's the one that really jumped out at me, obviously. That if you go to April, about 3/4 of the way down, you'll see that $38,000 charge. That's a big chunk. And so that one begs some context and footnote. This is due to a current core contract The payment is reflected for the 2025 calendar year. That invoice was not received until February of this year and may have been delayed further due to contract negotiations. So we're just getting our share all at once. Is kind of what we're talking about there. There was sort of interim lead or a gap contract, and we're getting that now. We expect the future invoices to be received and processed in January of each year. The contract terms reflect a payment plan of 5 years with an option for years 6 and 7. Each payment will be approximately a 3% increase year over year. So that's just, generally what we have in place now. So you'll see some increase there, but you'll get those technology increases in the future, probably somewhere around January or February. But while we were in negotiations, we didn't get that bill for this term until now. So you'll see a big chunk in technology again next year and the year after that. Okay, for our portion of for core. Other than that, everything else is tracking.
Glenn, I got a quick question. Are those distributed pro rata among all of the
Yes, sir.
licensing boards?
Yes, sir. Obviously, any other expenses that are unique to us, application upgrades, enhancements, stuff we ask for, we pay for that. But contract things that apply to everyone is pro rata, and that, like all administrative cost backs, I don't have the formula in front of me, but you're looking at the things they're looking at is licensee size.
Yeah.
Complaints, and they and projected plan based on those. And sometimes you'll get a reallocation if we fall below the projected plan. But those things that we all share in administrative cost backs, some of those it's reconciled there. There's things unique to us that's in Edison. That's the one up top. So you got accounts that look almost the same. You got Edison up top. That's us. That's basically our ledger saying this is what we just assign that regularly expenses. Then you got administrative cost backs, which is our share proportionate pro rata with others as well. And sometimes also there'll be things that just aren't in Edison that are itemized there. But to your point, yes, that's our share. So obviously we're going to pay a little bit more with 20-something thousand licensees and court reporters with 200, and so theirs would be minuscule.
And that was my other question is how do we run? I don't even know how many licensing boards there are. I know it's a large number. Where are we in the hierarchy?
The A&E is not a small board, but I'm just off the top of my head. Some of the larger boards are Cosmo and Barber. They're going to pay more than you guys. They've got like 60,000 licensees plus, and last time I checked, so they probably got more than that by now. But Cosmo and Barber, then you got Motor V, that they're huge. Contractors is another. Real Estate Commission, that's another. Those are the ones that are big. Those are the big buckets, and then probably us right underneath that.
Okay. Does the bar or the medical licensing board? They're not part of.
No, that's Department of Health. They're next door, probably having a meeting right now. So, but and their system looks very familiar. They use the same vendor as us. Their system isn't called Core, or Reg Access. It's called LAR, L-A-R-E, or LARS. Yeah, licensing. Tammy come from there. She could give you all about that. But they're next door to us. But they
we bring them under our banner so that they can share in these costs.
Yeah, I don't know if we want to share in their costs. Laura makes a good point. Yeah, we're pretty lean and so I'm really grateful and on this board too. You guys doing a lot of using our associates and and also our voting members for those expert reviews. That saves us a lot of money too, given the complaint. So we're doing really good on that end. All right. Any questions other than that? I'll just jump out at you. Yes, sir.
I just have a question on the legal cost back. How does that tie into the investigator's costs? When someone files a complaint, investigators, obviously we know what they may be doing, but from a legal standpoint, that price that we pay for that particular case, is that being or is that something that could be, if it's not being considered as part of a fine?
Yes.
Is it already?
Well, not yet, but we are. That's in discussions. We do want to add that to the bill because you go to court costs if you get pulled on the side of the road, and that gets wrapped right into that. And we haven't up to this point, but that is something admin across the board is like, we don't want you spend thousands and thousands of dollars litigating this thing, and then somebody walks away with a $200 fine or something, and we're at a deficit for that. We're running a loss for that. Well, then you magnify that. If you're a board the size of contractors, NBC, or some other folks, you magnify that to scale. Well, now you've got budget problems. I mean, you're dipping, with those margins. You're looking at fee increases or whatever else, and so you're penalizing the larger pool for these bad actors. So yes, that's something that will be in discussions at ongoing. You'll find that up at case revenue at the very top of revenue. Where you see case revenue,
Yeah.
that's where that's what they paid in for this month. So obviously April, $1,800 there in fines, and so you hopefully once that comes on board, we assess that and then collect that. You should see an increase in that regard.
And that's statewide? Is that what you're thinking?
Well, division-wide, just reg
Division-wide,
boards.
okay.
Yeah. We don't. What they're doing over in health, they may already be doing that. I don't know, but reg boards, right? It's been, pursuing that.
Yeah. I knew there was a conversation a while back about the possibility of that. I was just curious where we were. So.
Yeah. No, that's good.
Not that legal's too expensive.
Well, and you'll notice if you go down the legal cost specs at the bottom, that's their billable hour, and that flux is based on what they're dealing with. The legal report, how much time they spend in that. Investigations, which I believe is below that, is if we spend out reg boards, guys. That's why you see that reallocation there, because we never use them. So expert review and the board and legal, that's who we need for what we do. And so we don't really use the investigation guys too much, and our expert reviewers, that's you guys primarily. So we save on that front. So thank you for your service in that regard. Every single time you help or you look at those cases, you're saving the board money. So yeah, and if we've got a rulemaking hearing, or we've got a rules package we're working on, or cases, or all the cases, if that takes some extra time because you're some back and forth, well, that's a billable hour. So you can all, based on our business, you'll see that ebb and flow right there.
Okay. Thank you.
Yes, sir.
Thank you.
All right. Unless there's any other questions there, and if you think of any, you can forward those to me as well, and I'm happy to go deeper and deep dive in that as well. But looks like we're ready for the comedy application review policy. Should have that on you. That should be document number 4. And if you recall at our last board meeting, that language that's highlighted there for the engineers, that was the board already made a decision to move forward with that. But once we make a decision like that, we have to update our policy. So that's what we're doing here. We're taking that decision that was made at the last meeting and updating our policy with it. Now in committee, the engineers did want to caveat that, and they added one little phrase. And committee or Mr. Collins, if I need correction, let me know. But let me reread and then add the section that they wanted to include in that statement. If prior discipline in another jurisdiction is at least 5 years old and the license was reinstated and remains in active status in the same jurisdiction without restriction as the stated discipline, the application may bypass the application review committee. So without restriction, we just want to clarify that, an active license, they're not on probation, or because we had a case just before that in their committee where we had a fella in Texas that was on restriction. And obviously that wasn't the intent of the board. Those will still come to review, and those need to be discussed. But for those without restriction, that was one clarifying that they made. And then they, at that time, voted to accept that. And then, Mr. Collins, if anything you want to add to that?
No, I had a question about when the 5 years begins. Is it from the point that the board issues the disciplinary action, or is it from the time that they have completed all the terms of their disciplinary action?
It would be, this is 5 years old. That would be, it would be signed order. It would have to be it's not just the event, but when they have litigated that, adjudicated that, and they've signed that order, or discipline has been rendered. Because then before then, they're still exercising their due process. So the clock starts when they say, "Yeah, I did it." And so that's when, and then they sign it, and it's a fully executed agreed citation. If that's what we're talking about. Yep.
And then if they have terms that they have to fulfill as a result of that signed order that extend for some time after that. That's okay for that to be within the 5-year period?
They would have to be fully restored, so you would assume in that case that that jurisdiction, if they've restored them, then they've met those terms. But obviously, if they don't have a clean bill of health, it'll still come before the committee. Yeah, there's no loose ends. There's no, kind of like our issue with our case in Texas with the restricted license, and not to step on any announcements when he gives the committee report, but on that particular case, that there was still restricted license. There was still some loose ends there. So we're talking about folks with no loose ends. 5 years from when they executed that agreed citation, and they are fully restored with no pending items out there. Yep.
I'd like to make sure that this new part we're adding does not refer to felony conviction.
Yeah, no, it wouldn't, because that would be fresh start, and that's a separate process. Yep.
Just make sure it's worded correctly, that it doesn't allow that.
Yep. No, and we had a couple fresh start discussions this morning as well. The engineers, they just went off the rails. They really misbehaving this time around. I don't know what happened over there. Oh, and while we're here, Chairman Collins and that committee, he said that we don't have to, I mean, obviously before us is this language, but if the architects want to consider something along those lines for their shop as well, we can discuss it here. We can discuss it another time. I don't want you to, obviously not putting you on we can do an architect application review committee next meeting or whatever, but if you're just feeling a hot burning desire to add that to you right now, then you could do that too, just to keep it all, efficient moving, but you don't have to, obviously. Any hard feelings or feelings about that, Mr. Waxter?
Frank, just for clarification, the sentence right before that says no record of disciplinary action or felony conviction.
So it would be the same tag.
Yeah.
Yeah.
But when it says if prior discipline, somebody might try to think that prior discipline was a felony conviction. I just don't want that.
Yeah. No, prior disciplinary would just be professional licensure. It's that language. Yeah. But conviction would be would be the wheelhouse, and but fresh start would always still apply.
Yeah, but I'm not speaking for Rick or Brian, but I think it would be good for us to add something similar in ours, just to let y'all take care of it before it even gets to us, basically.
What do you think?
I agree with Frank. I think something like this would be appropriate in our language. I don't know if it's the exact same language but definitely I'm in favor of that.
Okay. What we'll do then is, unfortunately, out of a courtesy to Mr. Tibbs, we can just reconvene then and bring it up at another time. But we'll pass this language, get it updated, get that moving, and then represent. Is that okay with you at a full board? Unless you feel the need, we can just present it to full board, and instead of meeting separately on a committee.
I think that's okay. Just present it to the full board.
Okay.
Yeah.
That sounds good.
And it may wind up being the same language.
Right.
I don't know. It doesn't strike me as there's a problem with it at all.
Right.
So.
And I mean, you can vote on now if you want as well. I mean, because if there's 2 out of the 3, that would be a majority anyway, and then the board themselves would be making the decision, not the committee necessarily,
Right. Frank, what do you think?
I'd like to involve Brian.
Sure.
Yeah.
Okay, sounds good.
So we want to come to the next meeting.
You bet. Yep.
Yeah, that'd be good.
All right, so in this case then, what we have is that language will be added for the engineers only then, and then we'll represent when Brian was able to be present with us. Okay.
Right. Thank you.
And we just
You
need
need
a
a
motion in
motion?
regard. Yes, sir.
So moved.
Got a motion. Well, yes, we got a motion from Mr. Heathcote. That's right. Do we have a second?
Second.
All right.
Excuse me.
All in favor, please say aye.
Aye.
Is there any opposed? All right. Hearing none, then that'll pass. Yes, sir.
Glenn, with this discussion, I'd also like to go back and look at the landscape architecture.
Yep, you bet. Yep.
So, and I'll do that
That's
before our
perfect.
next
Yeah.
meeting.
And then we could just package those things together in that one. Yep, that'd be great. Thank you for doing that. Yep. All right, let me get my notes right. So. Okay. Looks like we're ready for the legal portion of our agenda and then our legal case report.
There are 5 cases on the legal report for this month. The first one is 2024-06811. This case was administratively opened, and the complaint was the respondent was a registered engineer. On the respondent's application, they answered yes to practicing while the license was expired. The respondent said that they accidentally selected yes on their application, but they have not worked with the public since their license had expired. They stated that in their current position, they do provide digital tools for managing instruments internally. I submitted an inquiry into the company's website to confirm the respondent's employment for their role and or duties to determine if they engage in unlicensed activity. A response was not provided prior to the submission of this legal report, and due to the inability to confirm the extent of the respondent's duties and the self-reporting on the application, it's recommended that they are assessed a civil penalty of $500 for practicing on an expired license.
I'd like to make a motion to approve.
I'll second.
Got a motion from Mr. Thompson to approve, a second from Mr. Wagster. All in favor, please say aye.
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 Any opposed? All right, hearing none, then that was approved.
Could I make one comment,
yes, sir.
if I
Yes,
could? And this has happened on several of these recently, is where the state has, or the state has asked for additional information, and they have not responded in the time frame in which you've asked it for, 30, 45 days, whatever the time frame is. To me, that's almost admitting you're guilty. It's just like, well, I don't have to do that. So to me, definitely a penalty is in order, and for future reference, I would think that might be a reason.
An incentive?
An incentive, thank you. An incentive to
I agree.
submit that information, and B, do the fine.
And it may solicit a response. The fact that we finally issue the order and the civil penalty may solicit a response from them, which we can revisit at that time. That's a shame that we have to. You'd think that somebody would protect the value of their license and respond and provide that evidence and disclosure, but.
Well, and not everyone that gets on this list is doing something that's underhanded or something like that. And things happen, I understand, but for people who just totally ignore what this board asks for, it tells me what type of character that they have. And that's my opinion. So, thank you.
I have a question. So, when the inquiry is sent to the respondent, are they informed that if they don't respond, they could be assessed a penalty?
I didn't do it for this one just because they don't have an active license. I think their license expired in 2021, but I can start including that in the language. I should just give them a deadline to respond. And
Yeah, I think
that'd be a good idea.
Yeah, I do too. I agree to add that language, but I also think that issuing the order and the civil penalty, if they haven't responded before, by getting the order and the civil penalty, if they still don't respond, again, even more definitively implies that there may be guilt there. Mm-hmm. But I do agree that language would be beneficial.
And we wouldn't put a dollar amount on that at that time, because that's before, when it comes before us is when we assign that dollar amount. So, if it's like $200, if they go, what's $200 or something? So, let them keep them sharp.
I got it. I can include that.
Yeah, thank you.
Okay.
All
All right, looks like we're ready for number 2 then.
The second one is case number 2025001141. The respondent is a licensed engineering firm, and the complainant was a former employee of the firm. The complaint alleged that the respondent advertised land surveying services without having a licensed surveyor on staff. The complaint included a screenshot of the respondent's website, which had a section advertising land surveying as a service provided. The respondent denied all the allegations in the complaint. The respondent stated that the complainant worked at the firm from February 17, 2021 to October 31st, 2024, and another land surveyor was hired from November 1st, 2024 as a full-time employee. And while they were a survey, they operated their independent surveying business while employed with that firm. The second surveyor's employment was terminated January 6th, 2025. After the employment ended, all references to land surveying services were removed from the website. They also say that the land surveying services, if they were needed, they were subcontracted for the work, and it's clearly outlined in their proposals. The response included various documents, including employment agreements with the second surveyor, simple proposal, screenshots of the website. All the documents that were attached were reviewed, and the screenshot from the complaint was taken on December 24, 2024. And during that time, a licensed land surveyor was employed at the firm. The screenshot in the response did not have a date, but after review, it did not have a reference to land surveying services at the time of the investigation. It should be noted that the complaint was also referred to the Land Surveyor Board, and disciplinary counsel say that they would recommend a civil penalty for offering surveying services without a proper responsible charge surveyor on staff, and for allowing surveyor to use complainant certification on a plat after they were no longer employed at the firm. But based on my investigation, I recommend that this matter be closed. And also, wanted to add that this was reviewed by James Collins. It wasn't on the legal report, but.
Yeah, also just to clarify, looking at their website, there still is one reference in there to them providing land surveying services, and has been there since they cleaned everything else up. They did miss one, so we do need to tell them to clean that one up as well to get that off of there. And it looked like they tried to do everything they could to get all the surveying stuff off after they terminated their land surveyor, but I was curious as to why the Land Surveying Board recommended a penalty. Is there something that wasn't quite clear when I was reading all the documentation about exactly why they decided to issue a penalty? But from looking at everything that I had available to me, it didn't look like they violated any of the engineering rules or law, with the exception of having land surveying on their site still. So I'm not sure that we necessarily would want to just close it. I think we still should do something to them for continuing to advertising land surveying on their website for the last 5 months, 6 months.
And as an update for that, the land surveyor attorney, they recommended a civil penalty of $2,000, and the board approved a $1,000 civil penalty for that one.
Really, I'm curious. I know it was an engineering firm that advertised land surveying, but really, to me, it falls under the land surveyor's purview and not ours. And they've assigned a civil penalty and dealt with it. Obviously, the firm hasn't, maybe accidentally, they left one off, but they need to be reminded that it's still on there, and then that they need to delete that reference too, unless they have hired somebody that is a licensed land surveyor. But as far as the engineering component of it goes, they really haven't, like you said, James, haven't violated any engineering rules or regulations.
You can do like a letter of instruction and tell them to remove that reference.
That's a very good alternative.
And maybe keep us updated, like they don't.
If they don't.
If they don't comply on that end, then since it's an engineering firm, that's where I think that's what James was saying. It falls under our judgment because it's an engineering firm advertising something they don't have. Not necessarily surveying, but they're doing something they shouldn't.
So I guess we'll need a motion in that regard. So instead of close, a letter of instruction. So we'll just need a motion in that regard, then a second.
So moved.
I got a motion from Mr. Heathcote for a letter of instruction, a second from Dr. Ash. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, then that was passed. Looks like we're ready for number 3.
The third one is complaint number 2024-067501. This complaint was administratively opened by the board. The respondent was selected for a routine audit. On October 30th, 2024, the respondent was informed that they had 30 days to support the continuing education claimed in their 2022 to 2024 renewal period. The respondent did not comply with that audit. On January 8th, 2025, the complaint was opened. The respondent was sent an offer to resolve the matter via an agreed citation. They did not provide a response, and the matter is referred to legal on February 11, 2025. To date, a response has not been received from the respondent. Registrants are required to maintain continuing education records for 4 years and provide the records to the board for audit verification purposes within 30 days of the board's request. Additionally, a registrant may be deemed by the board to be guilty of misconduct if they fail to respond to the board's request and investigations within 30 days of mailing communications, unless an earlier response is specified. Here, the respondent did not provide proof of their continuing education for audit purposes, for the audit period requested, and they failed to provide a response to the complaint. It's recommended that the respondent be assessed $500 for failing to comply with the requirements, and then assess a civil penalty of another $500 civil penalty for failing to comply with the requirements to respond within 30 days, and then require the respondent to submit the record of their education and require the respondent to take and pass the rules and laws exam. Sorry, it was like a lot.
Quick question. I continue to be amazed at people not responding to something that threatens their license. Are we certain that we've got the right address and contact information for this person after 2 attempts?
Yes, anything that they have is in core, and they're responsible for updating all their information. So everything's sent to them, and they get multiple notifications from our end. So I don't know why they're not responding though.
Move to approve.
As a licensee, it's up to us to keep the address correct with the state, so.
I just have one small correction, just a technicality, I think. On the regs, that reference to the regs 0120 0410 14C, if that could be amended to 0120 02075C. I think that 04 is a reference to interior design. It's the same. It's almost the same language, just a chapter or verse.
Thank you. That'll make the correction.
All right, so we have a motion on the floor to accept council's recommendation. Do we have a second?
Second.
Got a second from Mr. Carter. All in favor, please say aye. And then we can do discussion now. That's okay too. Go ahead.
So what happens if this person does not? We're going to fine them $1,000, but do they continue to practice? Do we put their license as pending, or it's a slap of the wrist. The biggest thing is taking your license away.
Yeah, that would be a
People
formal
ignoring the
hearing, or that'd be an emergency hearing or a formal hearing, because it's a property right and they have to go through due process. So we give them a agreed citation, and so they're still practicing until
We're coming up on
otherwise.
renewal too,
Yeah.
so we could deny the renewal. I don't know.
Yeah, it's
throw it
well,
out
obviously legal's here, and I'll not to get into heresy, but I'm sure she'll bring me back. But if it is a property right, it was determined at some point that even renewals are considered property rights. So if you're going to go that direction, then you have to litigate that. It's not just, and you have to do that in the terms of what 62.2, 308, or whatever the statute is. When we're looking at the other as well, we have to our application review. Remember, we went to the statute that
Yeah, I guess what I was driving at is on the application renewal, you have to make truthful statements.
Right.
And if they don't make a truthful statement, and then we request to their information. that's
Yeah,
kind of what
and,
we're-
yeah, and, if, you know, which talking about some material misrepresentation, that would be a complaint, and then you still go through the process, and it could be a formal, and, you know, yeah.
Upon renewal, do all fines have to be taken care of before the renewal's passed?
Yeah, it's not like, go ahead.
So if somebody on their application for renewal somehow does something that makes that application incomplete, then we're not going to just process a renewal for an application that has incorrect or incomplete information. We can't just hold off on a renewal because of assessed penalty, because, you know, when Ariel's making her recommendations, what she's talking about is like, here's what the board would assess if this went to a formal hearing, if we were to prove this in a formal hearing. But then we're going to attempt to settle, and almost every case does, settle these cases through a consent order, which means that they're going to agree to that. So until they've agreed to that fine, it's still disputed.
But at what point do we take other disciplinary action? Like Eddie was talking about, when they come up for renewal, if they check the box yes, that they've satisfied the conditions of their continuing education, and we know they have not, then
Well, so that's a situation, like I just said, where like, if that's, at that point, we're not renewing their application, or sorry, we're not renewing their registration because they have submitted an application that we know is incorrect or incomplete. Does that make sense?
it does, but still, I don't want to set a precedent by saying, oh, well, they didn't pay their fine, we don't have any recourse.
That's not true. It's just, there is recourse. There's recourse. We do go after people that violate the rules and the statutes, but it's not one-sided. They have a chance to defend themselves. We have to prove in court that they have violated the law before we can take any sort of unilateral action.
But in this particular case, you've given them 2 notifications, and they haven't responded.
Right.
They've chosen not to respond.
Yeah. We'll
So
see
what
if they
makes us think they're
respond
going
to a consent order.
Okay.
If they do not, then that's when my litigators, so Ariel in this case, would probably reach out to them again. Like, we do try to settle cases. It is like the most cost-effective way for us and the respondents to like dispose of a case, but they don't have to sign a consent order. They're entitled to come before the board or an administrative law judge and like plead their case if they think that we have accused them of something they didn't do. And so they have that opportunity. And then we also have default hearings, this is when we have a respondent who has just never responded to us at all. And the default hearing, we still have a hearing. We still
Whether
prove
they
our
show up
case,
or not, right?
Whether they show up or not. And then also recently, where we've started using motions for summary judgment. And that's when there are like no facts in dispute. You kind of file that with a judge, and the judge will grant it or not. And we use that a lot when we think a case is headed towards a default hearing and there are no facts in dispute. So there are definitely options. It's just, this is due process. It just takes time.
So it steps into the legal world, is what happens.
Yes, yes.
Okay,
We're in
so
the legal world.
I'm naive to the legal world, but I prepare a set of plans. I submit it to my local codes person. They redline the plans, and I refuse to make the changes, don't want to make the changes, but they hold my permit. I can't get a permit.
Right.
There seems to be a similar kind of analogy here. How is it that codes can hold my permit because I disagree with them when we have, in this case, we have an applicant who will not provide us the information? I mean, I know I'm reaching here, but it seems like the board ought to have a little more to flex our muscle a little bit more than,
Like related
than realizing
to
that we have to go to court.
I can try to have, I can think about that some more.
I mean,
This is generally how we've done it, because we want to make sure that we're giving people, all the protections
Sure.
that they're afforded under the Constitution, and that we're not stepping on that.
But these are simple requirements.
Sure.
They're
I
simple
do
requirements, and
think
all of us.
there is an ability for the board upon renewal, but it's not as straightforward as you have an unsigned consent order.
Right.
It's got to be like, you have not provided the board with the information needed for us to process your renewal. It's a little bit more nuanced.
What happens if you process the renewal and they don't pay the renewal fee?
Oh, well, then
Yeah, that's.
I'm
That's a
getting,
whole-
I'm getting basic here, but
Yeah.
I'm looking at this.
We
It
will
says,
void the license, but even
Yes.
that requires quite a process, because we have to give
Right.
them the ability to, we have to notify.
It's like
This is government. There's a lot of notifications, there's a lot of letters, there's a lot of chances to correct your behavior. But in the end, if we have followed our process, the department has a what's it called? Is it the collections policy?
Yes.
The collections policy. The department has all these protocols we go through in that specific instance. And if we follow through, bad check policy, that's it. I should know.
was
It's
just
just a
reading-
lot. But if we go through all of those processes, then we can sort of void the license, and it will be as if it was never renewed. But again, even that requires,
a different
that's not just
process.
Glenn freewheeling.
Well, I was reading through the requirements for renewal, and it
Mhm.
says the required renewal fee, evidence of having completed the number of professional development hours, all in the same sentence.
Yeah.
So I was kind of relating, if you don't pay, it's almost the same as.
Well, yeah, if we have evidence that you did not complete your CLE, or sorry, your, not CLE?
Pediatric.
CE, sorry. You would, but see how that's different? You have not completed the required renewal application, the requirements for renewal.
And if there's any question of whether or not they meet the requirements for a renewal or for an application, that's why we have application review committees. That's why we talked about those 3 cases, because they might be subject fresh start, or they might be subject to 622-308 or whatever for it's all spelled out, what revocation, suspension, or, denial would look like. What you wouldn't want to do is, because they don't sign a consent order, you de facto suspend or revoke them through a renewal.
Yeah.
You see what I mean?
Yeah.
And then you've denied them due process, so you can't do that. So if they meet the requirements, then you have to issue that. But so that's a separate process, separate track. And then as far as fines or fees and paid, as far as that goes, we have a collections agency for that as well. But then you have to have a court order for that too. It's like a garnishment. They can go all the way up to garnishment, but they don't just do that because you want it, or because they it has to go all through all the process.
I've got a question that, where it says require the respondent to submit the record of their education that was requested and audited within 30 days of receiving the consent order. All right, let's say we approve this. What happens in 31 days when he doesn't respond?
They can be brought back in front of the board for failure to comply with a request
I
by
mean,
the
does
board.
this keep coming back to us and bouncing around?
Hopefully not, but if they don't respond, then we can assess an additional civil penalty.
Yeah, I mean, I think if it comes back, we go, well, okay, we've got a $20,000 fine for doing this. See what they say. I'm being facetious, but it's like I feel really weak in being able to enforce this.
Well, yeah. So I'm feeling that. That's how you guys are feeling. And so we will try to come up with ways to be more stern. I mean, we have to stay within our process, but there are certainly always different strategies. So we'll certainly take that into consideration and try to figure out how to move through this process maybe a little more boldly or aggressively. But I mean, some of this stuff is just.
Hey, Laura, could you just add the caveat that continued non-response may result in revocation of your license?
Yeah.
Or non-renewal of
She
your
can
license?
definitely always say that, because that's true.
That is true.
That is true. So, We can definitely add that language just to make sure people understand like how seriously we are taking their violations. Right?
Yeah, I think it's also included in the consent orders.
Yeah.
I don't want to run scared of the law, but I think that the board needs the ability to say, look, these are the rules. You abide by the rules. You don't abide by the rules, then this is the ramification of that. And then if we're challenged legally, then we are. But I think that our position needs to be, no, here it is, and here's the ramifications, period, until we're challenged legally.
Okay.
Any more discussion on 3? No. We had a motion and a second to pass, and all were in favor. Is there any dissent or nope? All right, hearing none, 3 passes, and I think we're ready for number 4.
Number 4 is a represent. It's 2023-025-121. As a brief overview, because this was presented to the board a couple years ago at this point, the complainant alleged that the respondent advertised as in-house engineering on his website and LinkedIn profile when it was not registered as an engineering firm. The respondent claimed they don't self-perform engineering, but instead partner with engineers and firms to perform those services. They claim to have electrical engineers on their payroll, but they don't design or stamp drawings. The board previously had authorized a civil penalty of $2,000 for consent order and formal charges for advertising engineering services without registration, and had the respondent remove all engineering designations from their website. The new information is that this case was inherited from a previous counsel, and while reviewing the case for litigation, it was discovered that previous counsel had intended to represent this case with a new recommendation to close the matter. The previous counsel had discussions with the respondent's attorney regarding the use of the term engineering, and that attorney argued that when viewed in the context and not in isolation, the term engineering was in relation to design build projects with engineering services performed by the respondent's partners with elite engineering and not the respondent. They also asserted that a strict interpretation should not be applied and referred to several exemptions on the Tennessee Code annotated 62-103 that doesn't require registration for projects or services for value engineering, industrial engineering, nuclear, biomedical, chemical, and aerospace engineering. The respondent believes that they fall under that policy and stated that contractors without in-house registrants offer design/build services and in no way authorized to perform actual architectural, engineering, or landscape architectural services. And they said that they followed the policy by offering design build services, by organizing a design team comprised of Tennessee registered engineers that are competent in the work to be performed prior to the time that they're formally proposed, and those engineers are involved in any activity and any preparation for leading to a signed contract. The reason I had this for discuss was just because of the varying recommendation and the intent, it seemed like, from the previous council. However, on my review of this and in speaking with Alton, I believe that the initial civil penalties should still be enforced. They're still advertising as in-house engineering services and as in design, and it seems like multiple places. The way that I understood in-house engineering is that they would be within their employee on their roster and inside of their company, and it doesn't seem like it's that in this situation. They keep on saying partners, and they do reference partners with licensed engineers, but almost as it's a separate situation. So it's like in-house engineering, and we also work with partners outside of it, and then also design build options and services. So that's the way that I interpreted it, and I believe might be on the same page with Alton.
There's a number of places in here where they still refer to engineering design. They refer to in-house engineering. They have a whole section dedicated to design build that's separate from all the other banners on their website. I don't want to go into a lot of depth about what I feel about their attorney's response other than the fact that it took significant latitude with our rules. Like, for example, it says, I think it was something in reference to, other than as stated in, I believe it is, 62-2-105, we didn't do anything wrong. That's like saying, look, state trooper, other than that one little sign that said speed limit 60, nothing told me I couldn't do 90 miles an hour. There are a lot of other innuendos and excuses for not complying, but even under the guidelines, I think that were adopted on January 9th, 2003 for clarification on design build, it says that contractors may offer design build services to the public without having to comply with the firm disclosure. And that was the other thing, that if they are in fact claiming that they're providing engineering services, they haven't filed a disclosure form. And supervision requirements of TCA Title 62, Chapter 2, Part 6, provided no architectural, engineering, or landscape architectural services are offered in-house. And there's a number of locations throughout this document that say in-house engineering or design. And it's very clear to me and I think to Ariel that they are violating this statute. Thus, the recommendation that we go with Rob's original recommendation with the $2,000 penalty and require that they remove those references.
Yeah, I would just stress the fact that we have, as a board, have already discussed it and agreed that that's what we ought to do.
Yes.
If we need a motion, I make the motion that we stay with our original assessment and move forward.
We've got a motion from Mr. Thompson. We've got a second from Dr. Ash to return to original motion that the board decided on this case. All in favor, please say aye.
Aye.
Any opposed? All right. Any further discussion? All right. Hearing none, that was approved. I think we're ready for number 5.
And the last one is 2024-06-2571. It's also another represent. And this was involving continuing education. And the new information for this one was that the respondents said that they didn't respond because they didn't monitor that email address regularly. However, they contacted the office after they received the consent order. They believe that the carryover credits would have been applied to the 2022 to 2023 audit period and submitted training records for the registration period between June 1st, 2022 to June 30th, 2024. They sent the hours that they intended to roll over from the period from June 1st, 2022 to May 30th, 2022, and believe they were sufficient to satisfy the requirements of the 24 continuing education credits. Since receiving the consent order, the respondent has been cooperative with the board and completed 24 PDH continuing education credits. The respondent was informed that the continuing educations wouldn't be applied retroactively, but say that it was done to show good faith and that they would stay in compliance. The respondent also took and passed the rules and laws exam. After review, it's believed that the respondent is still not in compliance for the 2022 to 2024 audit period. They were notified that the specific credits wouldn't be applied, and additionally, all registrants were notified that the carryover credits for continuing education would end January 1st, 2023, and only registrants whose license expired before 2023 would qualify. The respondent's license renewal was in 2024. It's recommended that the respondent be assessed civil penalty of $500 for failing to comply, and for maintaining the continuing education records, and required to take and pass the rules and laws exam. That was, and then the new recommendation is just that. It removed the requirement for the 30 days to provide the continuing education from the original recommendation, just because they don't have it to provide.
Yeah, so this is, kind of gets back to some of the discussion we were having earlier about being honest on your renewal application. The applicant said that they had completed their 24 hours. When they were audited and they sent the information in, they provided a bunch of PDH stuff that does not comply with the law. So they had lots of half-hour courses that were on separate days. They had included the carryover stuff, and then they had also included 2 courses that they took after their period expired, and said, okay, you add all that together, and I have my 24 hours. So when you take all the stuff that doesn't apply out, and even if you give them credit for the PDHs that they did that were carryover that met the rules and the additional that they did, they still were short of their 24 hours. And so they then have gone back in April, latest last April and 1st of May of this year, and in the matter of about 4 days, took 24 hours of courses and, submitted that. And they actually submitted that with certificates. The first stuff they didn't provide certificates with. It was just, I took all this stuff and listed of it. So, again, it gets back to the question we were talking about earlier. This person obviously did not have an appropriate number of hours. They said that they did. When they audited, they manufactured a bunch of information that still didn't show that they had enough time. And so I don't know if the $500 penalty is enough, personally, for what they've done. We might want to think of something more stringent than that. And then they have not done anything to really satisfy the 24 hours for their previous renewal period. And, I don't know if we want to allow them to use the 24 hours that they did in April and May of this year to satisfy that, and they got to get 24 hours for their additional 24 hours for the next renewal period. There's some issues there that we need to figure out how we want them to proceed from this point.
The civil penalty can go up to $1,000 per violation. Just so you're aware of the range.
James, quick question, and I apologize for my confusion, but did the number of approvable PDHs that they got satisfy the condition for where they were short in 22 through 24?
No.
Still not?
No, right.
Okay. Did what they did in April catch them up?
Yes, in April they did 24 hours in a matter of about 5 days.
But was that enough to satisfy 22 through 24?
Right. Because they had about 14 hours of approvable time in 22 through 24.
Okay.
So they need 24, and they had 14. So if you add some of that time that they did in April to that, then you would cover that. But then we need to make sure they understand those 24 hours
were attributable to the previous
and they still need to do 24 more for the next renewal period.
Okay.
That they're in, in the time period they're in right now.
Yeah.
And do we, I guess to that point, do we have a method knowing that this individual has stretched the truth before when, our audits are random, right? But do we have a method of making sure that when this person goes up for renewal in 26, that they are automatically audited?
We can, we don't, it is random. And so it's not necessarily that would be the case. I mean, obviously there's some latitude in your recommendation.
Can we not just
flag it?
Knowing this and flag
Right.
it, yes.
Yeah.
Okay.
Yep. So there is a mechanism for flagging cases. But one thing I would say too is, and not to, just to give you some context with other boards, because I find that helpful. But there's a agreed citation schedule letter in 3 boards that I'm aware of, 1 auctioneer, 1 in land surveyor, 1 in collections, where they don't present it to the board if they misrepresent it. Basically, we audit them. They come back and say, "No, got me," Then we just automatically send them an agreed citation. They sign it. It's done, and then it's and the terms is $100. Now, obviously, you put more work in it. You're like a borderline CPA with your big calculator, taxes, trying to find all that, and so obviously this is a little bit different scenario. But my point being is sometimes we start small and then build because we're trying to incentivize them to own up, because eventually you build up, you keep adding the heat until you take it to formal, So you don't have to do that, but I'm just saying that's been the strategy with other boards. They just sort of escalate until they get what they're after, which is basically a settlement, But typically, and as well, just the criminal side. I mean, I wasn't a criminal attorney like Miss Ariel here, but I watched some Law and Order, and stayed at a home, a Home Inn Express, right? A Holiday Inn Express, but yeah, y'all did too. So yeah, we got the greatest legal minds right here. But typically, as you noticed, they start small and build. They'll typically if you go to trial, then that's when they're going to throw the ideas. That's when we throw the book at you. We open up the score, but you can take this plea bargain now, so that's kind of what we've done with the other boards. So I'd say you're within range, but right, he does. Obviously, he was obfuscating and running you all over the place, and that's disrespectful. Obviously, when somebody has you dead to rights, and then you're throwing everything against the wall, hoping they won't notice, or you'll just out of fatigue just say enough. But that's obviously not the case. So that's before you. Any discussion?
Looks like
I'm
Go
reminded.
ahead.
I'm reminded that we're here to serve the public, but to protect the public. And PDHs are that. That's one of the mechanisms that we do that. And I don't know why we would treat this individual any different than I am treated. I keep track of mine, and I don't like it. I hate keeping up with all that stuff, but I do. My license is that important to me. And that's why I do it. And I sort of naively believe that everybody else should do it as well. So,
Yeah, and that's why we have a complaint before you. And so at this point, it's just what range do you want to go? And did you have a recommendation in that regard, Mr. Collins?
Well, I agree with Ariel that we probably ought to bump the fine up to $1,000. And since documentation on the other PDHs that he claimed was never provided, then if anything, we may want to accept the 24 hours that he did this past month as his PDHs for the previous period, and tell him that he needs to do 24 more PDHs for this period that he's in right now.
And just too, in our agreed citation letters and other boards, that's what we included. That obviously, you still owe us that. So you're in arrears. So it's not like you can just sort of pay the $100 and you're good. You know what I mean? You got to do the 30 hours, the 24, or in this case, 24 for you guys too as well. With those other boards, you still owe us that. So you do that, and it's not like you kind of get a pass for the next one. So yeah.
Is it would it be a violation of protocol to notify them in the order that their renewal will be flagged, and that we would, for assurances that continuing education criteria were met?
I'd have to defer to Ms. Carter. She would know what the parameters are, the scope, or the allowances, and those agreed citations are.
I think we can monitor them, and I can have a conversation with them. I'm not sure about putting it in writing as far as that goes. I can think about that a little bit more, but
Maybe
my initial thought is maybe not putting that portion within a consent order, but we can definitely take above and beyond the 24 hours required for that. So let them know they have to do more. Continue.
I'm not asking that they do more. I just want them to know that when they do come up for renewal, that they should expect to be audited, and that because of the failure to comply with this one, that when their next one comes up, that it will be flagged for review. Yeah.
I'll work on the language. I'll put I'll work on the language, but I think we can probably put that in there.
Why don't we find out how many CEU hours they're deficient and charge them $100 per hour for everything they're deficient in? And that would be limited to $2,400. But, and again, that's just suggestion. Because if people know that on the front end, they'd be more likely to get there.
Yeah, I don't know what the scale is, but I think it's like up to 1,000 per, is that what it is? It's, you know,
It's $1,000 per violation.
yeah, per violation. So you would be
Okay,
limited to
$100 up to $1,000.
Per violation.
Yeah. And so right
Per
now we have one,
violation, yeah.
we have one violation, which is failure to meet his PDHs for his renewal. So that would be the one violation. So you'd be capped at 1,000.
Do it twice.
So,
Okay.
so they're short, how many hours did you say?
Yeah.
Based off the information they provided for the audit, they're short 24 hours because they didn't provide any certificates or proof of the courses that they claimed that were ones that were acceptable time frames. If you say, okay, those are good anyway, then he was short 10 hours.
Okay, so none of the 24, and especially the rollover part, because that was
Right.
history. So they're short 24 hours. So what I'm hearing is that we're suggesting to raise that fine to 2,000 or to 1,000. I'm sorry, to 1,000.
I think we're limited to 1,000. Yeah.
So we'll raise the fine to 1,000, and then we require that they make up that shortfall of 24 hours. So they still owe us the 24, and their fine is 1,000, and then the renewal is a 2-year renewal. And at that time, we need a flag on their renewal, and I suggest that we do an audit at that time. And I know they're, but our flag lets us know that those have been bad actors, and we need to keep an eye on them. So is that the motion?
Yeah, that sounds good to me.
Is that my motion? I make that motion.
Just for clarification, it's doing the additional PDH continuing education hours, the increased civil penalty to 1,000 instead of 500, and we're going to flag and review their account. So when it's up for renewal, we'll essentially audit them. And I know that before it was also pass and take the rules and laws exam. They've already taken it. Do you want to include that one in this one just so it's part of it?
Just part of it. Yeah.
Although they've already completed that portion of it?
Yeah.
Okay.
It's just part of the record. Yeah. Okay. That's my motion. Thank you.
That was a very articulate motion there, Rick. You did a fantastic job. Yes, sir.
So I have a question. So this, I can see how this would be a little confusing during the next renewal period. Is there a mechanism in place to say, okay, you caught up, but you don't get to double dip and use those again for your renewal? Because those were catch-up. So is there a mechanism in place to flag those so that they're not recounted?
That would be satisfied in coordination between our auditor. In this case, it'd be Sandra. She does the audit. What happens is agreed citation, and then the legal, whether that be Chris or the paralegal, whoever's working in that side of the shop, reaches out to us and says, have they done X? You know, this, and then per the terms. And then he has to make that case. Yep, I've satisfied the former, I've satisfied the present. You know, until he does that, then he hasn't met his obligation. I'm assuming it's a he. I haven't looked at it, but since, so yes, there is a mechanism. I kind of went around the world, but kind of like with the laws and the rules exam, Chris, when we have that, he'll send me a receipt that shows, look, they paid the fine, they've signed the order, and then I grade the exam, and now they've satisfied that. So we're working together, is what I mean. We can do that. Yep. So we got a motion. Do we have a second in that regard?
Second.
Got a second from Mr. Wagster? Is that right? Or is it? Yeah, okay. So we got a motion from Mr. Thompson, second from Mr. Wagster. All in favor, please say aye.
Aye. Aye.
Any opposed? All right, hearing none, that was passed. Did while we're in legal, did they have any other thing that
Yeah,
they look at.
the only other update from legal is that the next board meeting in August, we're going to have the rulemaking hearing related to the rules that we have been working on previously. So these are going to be the definitions that you all worked on, and then also all the rules related to the retrospective rule review. So we will have a court reporter here for like probably just the beginning portion when we do that rulemaking hearing, but you'll get all the information like when you normally do, when Glenn sends you all of the documents prior to the board meeting. But I just want to let you guys know that we are at that next step. So
Thank you, Laura, for moving that across. I know you guys have been waiting on that for a while. That's the last step for us. I mean, this is the rulemaking. We've already approved the rules, so this won't be news to you, and Mr. Lim will get a chance to look at it. But if there's no substantive changes, then those won't get recycled, and then the court reporter will record that. Whatever public comments we have that come in that day or otherwise will go along with the record, and then the GovOps will get a chance to look at that. And then when they approve, then it's effective and it's done. So
I will, I suppose, congratulate legal on, at least for the engineering component of it, taking a 7-page document and editing it down to 2 pages. I think they did something pretty similar to architecture too.
well, we try to be as concise as possible. So
You're the first person in history that ever called an engineer wordy.
no.
So the August meeting is the opportunity to present potential edits, or do we need to do that between now? And the reason why I ask is that there is some comment from Susan Ballard, from CIDQ, I think, from I-Corps, wanting to address some of the comments for clarity. Does that need to happen
she can
between
make her
now and
comments.
August?
Yeah, she can actually, that notice went out for the rulemaking hearing already.
Mm-hmm.
And so she can either send it to me or to legal, or I think the contact, I don't know who the contact person was on that, but whoever the contact person is, they would send their comments to that person, and that probably Scott or me. It's fine too. She can send it to me if she wants.
Okay.
But and then that becomes a part of the record, or the day of, she can call in or a show and then talk about that. But if there is substantive changes on what you've discussed, then that could potentially, not to disincentivize, but it could have to go through re-review.
Yeah.
And then you may find yourself at another rulemaking hearing. That happened to the land surveyors. It's okay. It's not like it's a terrible thing, but we had a rulemaking hearing and they wanted to make further edits. The edits, typically, we try to get those before rulemaking hearing, because by the time you get to there, you're kind of late in the game. Any substantive changes could recycle that package. I know you guys have been waiting on it for a few years.
Yeah.
So, it'd be great to get across the board, but obviously, if we have some substantive changes, we'll do another rulemaking hearing, and yes, sir.
I have a comment regarding that, and this is not directed at you or interior design, but we have to have a point where we stop. And if someone comes in and they want to make it if and or but, the board has the authority to say, no, we're not going to do that.
And one thing I want to keep in mind too, like, this is a really big package, right? Yeah. And so if we get this one done, then we can do a rules package right after that with the cleanup. Like, there's additional pieces that were like, I wish I would have put that in there. We did that with land surveyors. We talked about that. There was a couple wish list items. It wasn't necessarily a cleanup, but it was just wish list items. And they're like, you know what, let's get this big. They had a really robust GPS, getting everything current with the industry. It was pretty lengthy. And they're like, they wanted to get that across the line. So they did. And they got that past GovOps. And now they're talking, about those other wish list items. So if there's some wish list, we can do another package. Like, I've got a couple items that, and during retrospective, I was like, well, I probably should have we could have maybe included that. It doesn't do anything. I mean, the progress will still accomplish once it gets passed. There's not a cleanup, but it's just stuff that would have been helpful. And now that I'm 3 years into the role, and I realize just administratively, that would have been nice to put that in there. And I know we've had some stuff, we've had some comments. I mean, I took something that Frank said recently, and I wrote that down. I've been tracking y'all's, your stuff. So I've got like a running list about 3 items, that when we get this across the board, then we can we can have that discussion again. I mean, we can have it whenever we want to. I'm not saying you can't. This is the board. They have that's their prerogative. But just strategically, it might be a good idea to get that one done. Unless there's just something fundamentally wrong with what that, what that package is, then, and obviously we need to, if there's something wrong or broken, we need to fix it. So I'm not saying that, we leave bad stuff in there, but we've looked at this one pretty closely. Yeah.
Right. And the conversation that I had with Susan was that, this is the finish line. Yeah. And her comments were not anything that were substantial. And, it was kind of that end if and what's,
Well, this is the time. If anybody has comments that they want to send in, this is the point of the rulemaking hearing, is for the public to be able to have notice of the board's intention and to make public comments. And then the role of the board is going to be to address those public comments.
Perfect.
And that either happens at the rulemaking hearing or that can happen after the rulemaking hearing. And honestly, that is just administrative. If there's like one or two comments, the board can discuss and then we move on. And then also I've had rulemaking hearings where things are, controversial or whatever. And so sometimes we'll say, okay, the attorney will draft some responses to these public comments and then the board will review them and approve them at the next meeting. So, so that will be the public is allowed to make comments. That is the purpose of the rulemaking hearing, and then the board's role will be to review those comments and then decide how they want to respond to them, whether that means making edits to the language or to just say, thanks. Thank you for your comment. But that is the board's prerogative.
Very good. Very good. Thank you.
Thank you.
Yeah, thank you for that clarification. And while we're talking about that public comment section, that's sort of a caveat, made me think about that. Public comment section isn't just sort of a free-for-all, Like if somebody gets up and we're not prepared to discuss that because we don't have any of the information in front of us, we don't have any of the documents, we haven't reviewed it, you're not obligated to sort of in a Q&A be interrogated, is what I'm saying. If someone asks a question and you haven't been prepped for it, you have no idea where they're coming from, you can just thank you for your comments and move on. You don't have to, you're not obligated, to enter into that exchange with them. And so, the rulemaking hearing is primarily with the public in view. It's their opportunity now to take a look and tell the board what they think about your rules, All right. Thank you very much. Thank you, legal. Did legal have anything else to say?
No.
All right. Okay. Looks like we have committee report. Tammy, if you would, she's going to, for the rest of the members, the notes that were provided by the engineering members. And then while she's doing that, Mr. Collins, if you'd like to update the board on what the committee discussed.
Yeah, so the thing that Tammy's handing out now is the summary of NCES Southern Zone meeting that was held in Little Rock. Just a couple of things to point out there. Something that's pretty important to us is that the Education Committee is looking at ways to try to promote licensure among college professors. It seems to be a trend now that more or less fewer and fewer college professors are licensed, and we need to reverse that trend quickly. The Committee on Law Enforcement is running into the same thing that we are about these work-for-hire websites like Upwork, and they're trying to find ways to combat that and plan to have additional information for us at the annual meeting in New Orleans about that. I think those are probably the biggest things that were in there. A couple other things. There was a position statement that's included in there on artificial intelligence that what they came up with basically mirrors what we've talked about on artificial intelligence already. So we're kind of ahead of the game on that, which is good. And there's also a document in there that was put together to better document the experience for the engineers between the time they get their FE and they apply for their PE. In recognition that the PE exam has become largely academic at this point and less about experience. And so this is a way of trying to document that they have obtained the necessary experience that's required by state law in order to get their PE. So it's a guidance document for people to use and not yet part of the model law or anything like that. But it's a pretty good document, something we may want to consider in our reviews. Beside that, we had a couple of fresh start reviews. As Glenn mentioned before, we had another application review for somebody that had some pretty serious felony charges, and then we also discussed the common application review policy.
Thank you, sir. Appreciate that. Okay, it looks like then we are ready for new business. Is there any new business by the board? Okay. Looks like we're ready for public comment then. Is there anyone in, let me check the sign-up sheet here first. That clearly was more performative because I don't see anyone hiding in the back. So do we have anyone online? Anyone? Okay, no one. All right. Hearing none, then Chair, it is your prerogative if you want to adjourn us, if you want to gavel us out.
Is there a motion to adjourn?
And you went, in this case, since we had approved the agenda, you could just adjourn us now since we're done with the agenda. That's
All right, we're adjourned. Thank you.
all right. Thank you, sir. Appreciate you.